Great.
Good morning, everyone. Welcome to the meeting of the Joint Standing Committee on the Judiciary. This morning, we're going to start with a presentation of the report of the Criminal Records Review Committee. And then we'll do a public hearing on LD 1818. Before we do that, we are going to start with our usual committee introductions. And I'm just going to call committee members in order on the voting sheet, starting with you, Senator Sanborn.
Good morning. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
And Representative Babbage.
Good morning, all. My name is Christopher Babbage. I represent House District 8, which is part of the town of Kennebunk.
Representative Reckitt.
Morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Moriarty.
Hi, everyone. I'm Representative Steve Moriarty from District 45, which is Cumberland, and the southern part of Gray.
And Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I'm proud to represent House District 12, which is part of Biddeford.
Representative Thorne.
Good morning. My name is Representative Jim Thorne. I proudly represent District 103, which is Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
And Representative Evangelos.
Morning, everyone. Jeffrey Evangelos, House District 91, and I reside in Friendship.
And Representative Newell.
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I proudly represent the Passamaquoddy tribe of Sabayak and Medoknaguk.
Thank you, everyone. And we're joined by our committee clerk, Susan Panett, and also our analyst, Peggy Reinsch. And we are going to, and also today, we have Representative Rachel Talbot Ross, who is one of the chairs of the Criminal Records Review Committee. Welcome, Representative. And we're going to begin today by turning the virtual gavel over, or the virtual floor over to our committee analyst, Peggy Reinsch, for presentation of the report.
Great, thank you. It's going to be a pretty bare bones presentation of the report. I was one of the staff people. I was one of the fortunate people from my office to staff the Criminal Records Review Committee with Jane Orbiton. It was chaired by Representative Rachel Talbot Ross and Senator Donna Bailey. The review committee came from a resolve that this committee, the Judiciary Committee, passed in order to have a more comprehensive view looking at you had several bills about criminal records and what to do with criminal records. Should they be sealed? Should some be sealed? Should marijuana convictions be sealed or expunged? Just a general way of going forward of helping people who have criminal convictions become productive members of the community without those convictions holding them back. So you actually voted ought not to pass on 6 of those bills and passed this Criminal Records Review Committee, which has 29 members, a very broad range of folks. And you can, if you have the report, you can see who all was on it. It's a very broad scope of people, certainly not all on the same page about what to do or where to go. The resolve itself established 9 different requirements or study elements for the review committee to do. And the committee recognized that it was going to be hard to get through everything and make comprehensive recommendations because they weren't able to start until October 18th, which was the effective date of non-emergency legislation. So the committee started with reviewing a lot of information about other states, because other states have been working on this issue at various times over the years, including clean slate laws, expungement, all sorts of ways to seal records. And so the review committee got a resource notebook from my office that had lots of information about the other states. It was very specific about what some of the states were doing, and there were charts about the different procedures and different practices that other states were engaging in to start making the criminal records not follow people around, whether it was expungement or sealing or certificates of rehabilitation or certificates of employability. So the committee was supposed to meet 4 times, and they requested an additional meeting. So in their 5 meetings, they collected a lot of information. They had people from NCSL, they had people from Media Law Resource Group, and then people from all the different agencies that use criminal records in their licensing and permitting process. So it was very clear that there are uses of criminal records, and the committee has to weigh all of those issues, how to make any changes going forward if information is not public. So the second meeting, we actually invited Laura Ustak, who's a member of the commission, to walk through the whole Criminal History Record Information Act. And it was clear that Maine actually keeps a lot of information that other states make available to the public. Maine keeps a lot of that information confidential. We used to call it non-conviction data. Information about convictions is always going to be public. Information about arrests, however, that are not further, there's no further prosecution of those arrests, that actually becomes confidential a year after the arrest. And so it was really important for the review committee to, in looking at what the other states are doing with all their, what they call criminal history, and comparing it with what Maine already has determined is confidential. So the review committee spent 4 of those 5 meetings, collecting information and trying to get a better handle on what other states are doing, what's working, and then what's possible. What are the different options in Maine? And one of the issues that has been raised all along is Maine may not be able to expunge records by passing legislation. And that's because the governor has exclusive power to grant pardons and commute sentences. And that's the pardon and commutation power. And I think this committee has actually discussed it at different times, that the legislature can't take that step because that might be encroaching on the governor's power to either pardon or reduce somebody's sentence. And we do have law court cases that address different pieces of legislation where a sentence was attempted to be reduced because of post-conviction behavior or while somebody's already incarcerated, or changing good time after somebody has already started their sentence. The law court has said, no, that is very much akin to the governor commuting a sentence, and you can't do that through legislation. Only the governor can do that. So we phrase that as a separation of powers problem, because the governor has that power. The Constitution very strictly in Maine says each branch of government has its own powers. And unless the Constitution says that they can exercise each other's powers, they can't. So the legislature does not right now under the Constitution have the ability to reduce sentences or pardon somebody. And that comes up in the question of expunging a criminal record. If a criminal record is expunged, does that come so close to the effect of a pardon that you've actually walked into only things that the governor can do? So we're going to come back to that question in a minute. The other thing that the subcommittee spent a fair amount of time on was looking at the law that was repealed by its own terms. It was passed in 2015, I believe, and it ended up being almost like a pilot program to seal records, Class E crimes of anybody who had committed that crime between the ages of 18 and 20. So it was not quite a youthful mistake, but a young adult mistake, a Class E crime. They could go through a process where they could have their records sealed. It was a court process, petition the court, and the court could seal that record, and the person could say, I don't have any criminal records. That expired by its terms. It had a sunset on it, and it expired in 2019, just as we were gearing up to look at either extending it or expanding it. And then we had the shutdown at the end of the 129th legislature. So even though the Judiciary Committee had passed a bill to go forward and reinstate that process, the legislature never reconvened to take up that bill. So Representative Talbot Ross reintroduced that bill with an expansion to more than Class E crimes. It was Class E and Class D with some exceptions. And that was LD 1459 last year. In the interest of supporting this resolve to create the Criminal Records Review Committee, you voted ought not to pass on that bill and 5 other bills, and asked the review committee to look at that. And so the review committee took some time, and when you get the whole report, you'll see that there is a chart in the report that compares LD 1459 with the law that was on the books and that sunsetted. And then it also has the comments from the review committee about, well, maybe this should be changed, or this is a conflict, or it would be better if we made it clear that, excuse me, there's only one way, there's only one group of confidential criminal records, and maybe we should kind of make this an adjunct to the Criminal History Record Information Act. So the committee spent time looking at that and what's proposed in LD 1459. And at the end, they recognized, the review committee recognized that they would not have time to really do a comprehensive slate of recommendations going forward. So their first vote really was to reestablish the review committee so they can continue working on more aspects, whether it's certificates of employability, clean slate legislation, automatic sealing of some or all records going forward. But they did say the first step might be to at least hold a public hearing on LD 1459, or what was 1459. I guess you can't really hold a hearing on LD 1459, but a proposal that looks like 1459 and incorporates those options that the members of the review committee thought were important to add to it or make changes to. And so that is one of the recommendations of the majority. And another recommendation is for the Judiciary Committee to explore that separation of powers question and see if there's some legislation that the Judiciary Committee can put forward that would make sure the legislature had the authority, if it chose to use it, to deal with record sealing or expungement and not run into the problem of the court saying you don't have the constitutional authority to do that. So the three recommendations from the advisory committee were to reestablish the Criminal Records Review Committee, and that is what LD 1818 does, and you're about to hold a public hearing on that. And Representative Talbot Ross had actually filed that bill before cloture, and that was accepted by the council. So that's not a piece of legislation that you have to use your authority to report out under the review committee's blanket. So that's the first recommendation. The second recommendation is for the Judiciary Committee to look at that separation of powers question and figure out if there's a way to go forward. And the third is for the Judiciary Committee to hold a public hearing and get more feedback on 1459 with the additional changes and suggestions. I know that there are some people from the review committee here in the attendee link. If I told them they didn't have to speak, but if they wanted to, that they needed to raise their hands and you would be able to call on them. And I know Representative Talbot Ross is here, and I'm not sure how much she wants to add at this point as she's getting ready for the public hearing.
Thank you very much, Peggy. Representative Talbot Ross, did you want to share anything with the committee on regarding the report?
Thank you, Madam Chair. No, I think Peggy's done an excellent job of giving you an overview of our very quick process. And so I just thank the committee members for the trust to have done this work, and there's nothing more to add. I'm glad that you all have a copy of it, and I'm all set. Thank you.
Thank you. Peggy, I did want to ask a question, and I don't know whether it is more appropriate for you or for Representative Talbot Ross, but we have a vehicle, a legislative vehicle that we could use to have a public hearing on the proposal that was 1459 with some updates. Is that right?
Yes. So in your process last year, you voted on not to pass on 6 bills. You passed this resolve, the Criminal Records Review Committee resolve, and then you carried over LD 1310, which is an act concerning criminal records. It's a concept draft that Representative Talbot Ross sponsored for you to be able to use as a vehicle going forward. So you could do that. You could take what the review committee has kind of collected with changes to 1459, and you could have that turned into a proposed committee amendment and ask for a public hearing on that if you wanted. You might also be able to ask for a public hearing on a draft that could be a committee bill anyway. My understanding is you really only have one opportunity to report out a bill other than 1310. And I'm not sure how you want to use that. You could always ask for a joint order to report out another bill, or to report out a constitutional resolution if you decide that's what you need to do.
Okay.
So short answer is yes, you could use 1310 to do that.
Thank you very much. There's some committee member questions. Senator Keim, go ahead.
Thank you. I was just wondering, Peggy, in the report, there isn't the minority, in this printed report that was mailed to us, we don't have the 2 minority reports. Is that correct? And is there a reason why they wouldn't have been added in?
Actually, they should be there.
Okay, so I'm just not finding them then.
They're long. Well, one of them is long. They're under recommendations, and the minority positions start on page 16.
Yes, I wasn't seeing that. Thank you so much.
Okay, so there were 2 minority positions, and these were on the recommendation to go forward with LD 1459 and have a hearing on it. And one of them is you need to consider some more language, some other issues about accessing public records and whether the media can access and publish records that are accurate, were obtained legally, and are newsworthy. That's kind of the standard that the US Supreme Court has said means, news media can go forward with publication. That was Samantha Hogan representing the Maine Press Association. Her report is listed there at the middle of page 16. And then Judy Meyer representing the Maine Freedom of Information Coalition submitted a little bit longer report. And part of her concern is that 1459 wasn't ready to go forward. And I think that's something that this committee will have to figure out. How to make those changes.
Can I ask a follow-up to that?
Yes, go ahead.
Just wondering, so those are the two minority reports. So then I guess my assumption is that they were the only two that voted in opposition to the whole report, then just those two? If you don't know, maybe you can just get us that information later. I was just curious to know that.
Right. Well, when you get the whole report, the voting sheets on the three motions are there.
21-2-5, I believe. 21 favor, 2 abstentions. 5
So
bad.
there was of the people who voted, there were folks that abstained and there were people that were absent, but the people that voted on the reestablishing the committee, the review committee, that was unanimous. The folks who voted, there were 1, 2, 3, 4 people who voted against the separation of powers resolution. And going forward with LD 1459, those were the only two who voted against that.
Thank you.
And I will put in the chat the where the whole report is online again.
Thank you, Peggy. Next, we have Representative Moriarty, but before you ask your question, Representative Moriarty, I just wanted to let committee members know that I need to dash off, as it were, to a different committee, and Representative Babbage will take over as chair of the committee in my absence, and I'll be back as soon as I'm able to. We're not able to hear you, Representative Moriarty.
Right. Thank you, Madam Chair and Chair Babbage. Peggy, I don't mean to split hairs, but LD 1459 was placed in the legislative files in early June. My understanding is the bill was dead at that point. So my question is it actually still before us? Is it something we can take up, given that procedural history?
Joint Rule 218 says you're not really supposed to consider things, but I think it would be different enough going forward that you can do that. You could turn LD 1310 into that. You could also you could get permission perhaps to hold a public hearing on a revised text to try to collect more input on it. You're right that 1459 was voted ought not to pass.
Thank you.
Okay, in the absence of Senator Carney, Peggy, I have a question for you. Regarding 1459, I guess what I'm asking is that they never deliberated because of time constraint to actually come out with a recommendation regarding wording. And in the absence of that, what we technically have is a concept draft. And the options regarding 14, the third recommendation to us are what, I guess, because I've always been a little bit concerned about putting the judiciary in the committee, in the committee as a whole, in the position to have to do the detailed homework to come up with the right wording when we have nothing before us as a proposal. That's a large ask, so I'm asking. The options would be to report out a separate bill other than 1818 addressing 1459's issues, or to have that become the charge of the new committee.
Right. I think one of the options that the review committee wanted you to consider is either using 1310 or creating a new bill, much like you do with some other studies when they have a recommendation, and to start with 1459 and incorporate the changes, the suggestions that were recommended by members of the review committee to 1459, and hold a public hearing on it. They're not asking you, a lot of times a study committee will say, we recommend that you pass a bill that does X, Y, and Z. The review committee actually didn't ask for that. The review committee asked for you to hold a public hearing and gather more input on that, recognizing that you hadn't held a hearing before, and so you hadn't been able to hear what people are saying on both sides of it, or maybe there's more sides of it, but in favor and opposition and other suggestions. And rather than recommending that you just go forward with the bill and pass it, they were recommending that you go forward with the bill to the point of holding a public hearing and gathering that information. If it came to the point that you chose not to go forward to enact it, I think that would be something that the next iteration of the review committee would take into account, all the testimony. But if you did go forward with it, then there's still plenty of other things that the review committee is interested in studying and making changes.
Great, thank you for that. Senator Sanborn? And Soupy, could you help me transfer? Thank you.
Thank you, Mr. Chair. My question is, I guess, also kind of procedural. It seems to me that I guess I would ask whether the Criminal Records Review Committee could hold public hearings in their next iteration, or perhaps we could amend LD 1818 to give them the explicit authority to do so. It just seems like an odd process for us to revive a dead bill, have a public hearing on it, and then kill it again, so that the Criminal Records Review Committee could give us feedback on better language or tweak it or make appropriate changes to it, and then give us new recommendations. It strikes me that a more appropriate legislative procedure might be to simply ask the Criminal Records Review Committee to gather that public feedback and information that we would otherwise receive at our public hearing. Of course, we could tune into that public hearing if we wanted to listen to it in real time as legislators, but that would smooth out the process and avoid this issue of sort of considering a bill that has actually already been voted ought not to pass in the 130th, which I think is procedurally quite problematic.
Right. I don't see any reason why they couldn't hold a public hearing, or you could write it in. I think that doesn't, right. It's certainly not what they were hoping for. But I understand the concerns about the procedures.
Right. 90 days after adjournment would be the end of July this year, we hope. So, Representative Moriarty.
Thank you, Mr. Chair. Senator Sanborn has raised touched on an issue that is somewhat of a concern for me. And Peggy, you may not have an answer, and I don't know who would. This may have to go up the chain to the executive director. My question is whether the current, with the committee that we appointed last year still exists, or whether it has sunsetted. If it exists, my preference would be to simply reauthorize it to continue. If we have to reappoint, there could be the possibility of new members taking the places of those who served last year and would be coming in basically cold and without the benefit of all the work done last fall. It also raises the possibility of a further delay. As the chair just indicated, if a bill to revive passes, it takes effect in July with a report date in early December. And if we learned one thing through the process this past fall is that would be that this issue is extraordinarily complex, and time is going to become a problem again. And you get on a treadmill where you're just reviving a committee. It does its thing. It runs out of time. You reappoint it. It works some more. It runs out of time. I'd like to avoid that. So I just wonder, and one way of doing that would be to keep the current committee in existence. Or if it's already expired or run its course, then I guess we'll just have to figure out a way around that.
Right. I think actually you might want to talk about this a little more after you hold the public hearing on 1818, which is coming up right now. But we certainly have some different options to pursue. We might be able to revive it retroactively, because when a study committee reports, once it submits its report, it's considered terminated, basically. But we might be able to revive it retroactively and keep it going. I know the intention was to have the same people serve on it, and I think everybody that was there was willing to continue on that.
Peggy,
Go ahead.
Well, I was going to ask: is there a precedent to build on here, as far as having a committee that has been budgeted, allocated an amount of money, and given a report date to have done their job, and then to have that work continue after the next session? And if that's the case, I just wonder if any change of wording would be necessary in order to install the same membership, unless there's an objection from the nominators.
Right. I think that has happened in the past, and I can go back and look at it. My memory is the precursor of the precursor of the precursor of the Right to Know Advisory Committee began as a one-year study, and decided that they needed to continue working, and it was continued into the next year. But let me go back and look at that. And I also see that Jonathan Sarbeck, who is a member, he's the district attorney in Cumberland County, and he's a member of the study committee, the review committee. I don't know if you want to hear from him now.
I certainly want to ask if there are members of the commission that would like to offer their input today, to have that opportunity to do so. If Mr. Sarbeck is available, he could perhaps address this issue and anything else he wants us to know about the report.
I'm not sure his expertise would be the issue of reviving a study committee.
Yes. Okay.
Good morning, everybody. How are you?
Welcome to the Judiciary Committee this morning.
Yes, nice to be back. I hope you all feel the same way. Thank you very much. For people who don't know me, my name is Jonathan Sarvek. I am the Cumberland County District Attorney. I was honored to be a member of the Criminal Records Review Committee, and as I was a representative of the Maine Prosecutors Association. As I'm sure you all know, the district attorneys here in Maine, along with the Attorney General's office, we are tasked with prosecuting individuals who are alleged to have committed offenses. We know the importance of criminal history, and we know the nuances when it comes to the criminal records. I can tell the Judiciary Committee that there was not a consensus among the Maine Prosecutors Association on what our position was with regards to this, and mainly it was because we didn't have a finished product. We didn't know exactly what we were looking for, and one of the reasons I'm here today is to advocate that the committee be allowed or permitted to continue with our work, because we do find it's very important. We know that there are many people in the last few years, especially because of the opioid epidemic and increased mental health crises across the state with limited resources, that find themselves entangled with the criminal justice system. I know from work done by Dee Clark, who unfortunately passed away, about her work with human trafficking survivors who unfortunately were entangled in the criminal justice system due to the coercion that they were being exploited at that time. And so how can you have that mindset of intent when it comes to whether or not you actually have control over yourself? And the same could be said for substance use disorder and mental health issues as well. So me personally, I think we're open to this idea of seeing what this committee can do. If there is a product that we can present to the legislature, to see if there is a way that Maine can catch up with a lot of other states in the country about relooking at criminal histories. I know that, like I said, this is not the consensus of the Maine Prosecutors Association, but we really are very interested in continuing this important work. I can tell you, being part of that committee was an honor, from seeing representatives from law enforcement to individuals in the treatment field, to representatives for civil rights. And we even had individuals who were incarcerated themselves. So it really was a broad spectrum of minds who have a lot of experience with the criminal justice system, but more than just the criminal justice system, with substance use disorder and mental health issues as well. And so I would ask that we be able to continue with that work.
Thank you. Are there questions for District Attorney Sarvek? Representative Thorne?
Thank you. I guess I'm wondering, are you optimistic that you can jump back in and find a resolve to some of these open-ended, unresolved issues? Or I mean, I guess did you just run out of time, or not have enough meetings to be able to get it where you want it? Or
well, at the risk of speaking for people that I wasn't represented, which is always dangerous, but I'm going to do it anyway. When you see the votes, when it came to abstentions, I think a lot of reasons that you had those abstentions from a yes or no vote was because we didn't have the language, and we didn't know exactly what we were looking at to really kind of give an educated view on where we stood when it came to a yes or no vote. I can understand the yeses, and I can understand the no's where they came down, given their representations on who they were, the mindset that they were bringing to the committee. But from the abstentions that you saw, which I believe were the Maine Prosecutors Association, I believe there were some law enforcement abstentions there. I believe there were some mental health advocates there that had abstained as well. I think a lot of them were sort of looking to see what this was going to look like at the end of the day. And I guess I would say I'm confident because I'm optimistic in general. So to answer your question directly, yes, I am optimistic.
okay, thank you.
Thank you.
Thank you. Thank you, Representative. Senator Sanborn.
Thanks, and nice to see you again, Mr. Starbeck. You look considerably warmer today than you did when you testified in my committee from outdoors on the sidewalk
Yes.
yesterday. So
I apologize I had to do that, but it was cold. So
yes, we appreciate you giving the input, even though you had to be outside to do so. So my question is sort of related to the third recommendation in the report, and to Peggy's comment that if we were to ask you folks to hold the public hearing, that wouldn't be what the commission members or the committee members would have preferred. And I was just wondering if you could give any insight on whether it would make sense in your view for the committee to gather that information more directly and then be able to use it in a drafting process if the committee were extended.
that's a good question, and I don't know if I can really give you an educated opinion on that. I think the most, the thing that I really appreciated about the committee was the broad spectrum of representation that we had. And I think that allowed for a lot of voices to be heard and opinions to be given on the direction that we went. And we did, as Peggy said, gather a lot of information, just historical information. Laura Eustek from the Attorney General's office was a very, I think, a very great resource for the history about what has happened with criminal records going back into the 70s, but also looking at what other states were doing as well, I thought was important. I can't tell you which direction to go in with regards to a public hearing. I always think hearing opinions from other people is always valued and should be listened to. So I don't know if that means public hearing or people who were part of the committee. I kind of have to defer to you all and your expertise on how to best do that. So I apologize, I can't really answer that question well, but I think that's sort of the mindset that we would have, that you want to hear from other people's opinions on it.
Mr. Sarbeck, just to follow there, anticipated consensus is one thing, but it seems to me it might be helpful to us if you had, as a criminal records review committee, proposed specific information and then had the opportunity to weigh in on that specific wording for us as an educational function, I think, when we deliberate.
I think that's one of the reasons I'm here today, is to advocate that we do get together and come up with that specific language to provide for the community.
Thank you. Are there more questions for DA Sarbeck? Thank you very much for being here today. Appreciate it.
No, thank you for your questions.
Are there other members of the commission? Senator Kime, would you like to say something first?
Yeah, I would, but it's just a bit of more of a process question, because even as we listen to the next bill, I'm going to be wondering this the whole time. So I've got to ask it now so I know where to put the information as I'm thinking about it. But if we were, and I think it's really a question for you, Peggy, just on process. So if the commission were to continue, they can't really continue their work while we're in session, correct? And then can you just remind me again the timing of what we're looking at? Because if we were to continue them, that would have to be, basically during the summer then is when they would be working, well, whenever we get done. And then they wouldn't, and then whatever they report would be the next legislature.
Correct.
Right. So we do run out of time. Okay, so I guess the timing of this does seem really tricky and difficult for us to take it up as well. Like I absolutely agree with what Senator Sanborn and Representative Babbage were sort of saying, like we need something a little more defined to take on in the short session ourselves. And I want to echo the reservation that Senator Sanborn did about sort of reviving an old bill. Yeah, so just wanted to express that and try to make sure I understood the timing here, which seems problematic. Okay, thank you.
Thank you, Senator Kime. Other comments from the Representative Moriarty?
Thank you, Mr. Chair. Concerning timing, if the committee continues on, presumably it will not meet during the second session because there are legislators who are members and they have other things to do. But if, in fact, we adjourn on time in mid-April, the committee could resume, let's say, on the 1st of May, as opposed to appointing a new committee, which could not really get to work until late July. So it's the difference between early May and next December and late July and next December. The more time the committee has, the more likely it is that they'll finish up their work in time for the 131st.
Thank you. And so the plot thickens because the legitimacy of the committee as an existing committee would need to be established to make that possible. Right.
So
Anybody? Yes.
if I could say two things. One, I see Elizabeth Ward Saxel, who is also a member of the review committee, has her hand up. But I also want to point out that we're still talking about the report, and we haven't actually had the hearing on LD 1818, which is you might want to do before you talk more about the details of extending the commission or reviving the commission, the review committee, sorry.
Got you. So Subi, if you could bring Elizabeth Ward Saxel in, if she is interested in doing so. And was there a hand up? Did some, I can't recall who it might have been, but
It was me and I put it down because Peggy's right. I can just wait and talk about it with the bill.
fine. Thank you, Senator.
Thank you.
Thank you so much for having me. Elizabeth Ward Saxel, Maine Coalition Against Sexual Assault. I did serve on this committee, but then also the predecessor to this committee and the predecessor to the predecessor of that committee. And so hearing Peggy's warning to not focus on what's going to happen with the commission, as that will be determined as part of the public hearing, I'm going to try to narrow my comments, but they are linked, so I will walk very carefully, and Peggy, you can give me that when I'm over the line, right? So I guess I disagree that you don't have quite specific language in front of you. And I disagree a little bit about the perspective of reviving a dead bill, because I think the circumstances are not normal, which is to say that the LD, 1459, was the product of the previous version of this commission's work and included a wide range of stakeholders, from esteemed organizations like the Maine Coalition Against Sexual Assault, as well as MCLU of Maine, as well as the prosecutors, as well as SBI, et cetera. And the product of that work was the bill that was 1459. When this committee decided to enable the Criminal Records Review Commission to move forward, it was charged with considering the full range of issues that were contained in those, I can't remember, 6 bills that you killed, one of which was that 1459 bill. And so the commission did, in fact, consider that language and has said, yes, you should move forward with it, with the caveat of that there were a couple of stakeholder groups, most notably the press, who were not involved in the previous commission's iterations, which is why you have that very specific language, but with some additional recommendations from the media. And so I just feel like there's been so much work put into this that, certainly our preference as an organization would be that you do, in fact, take this up, because you have quite specific language, I think, available to you. I get the short session issues, but if we put this off, as folks have noted, and send it back to a revised version of a commission that may or may not exist that I'm not commenting on, that will significantly delay the next steps for that work that has been really quite a lot of work has gone into it. So those are my comments with all due respect.
Thank you. Thank you. May I ask you, Ms. Saxel, if then what do you not see as justified then the abstentions that were described by DA Sarbeck as being because they didn't have specific wording in front of them?
With regard to the language
The
considered.
third recommendation, yeah.
Yeah, I don't frankly fully understand that, as the DAs had a representative who was not DA Sarbeck, but DA Lynch. Is that right? DA Lynch, who was at the table for the drafting of that language and was back and forth with the prosecutors, as I understand it. But it may be that I'm misunderstanding what happened during the process of drafting that legislation, which Representative Talbot Ross was around for all of that. So she might, give the thumbs up or thumbs down.
Thank you. Senator Sanborn, do you have a question?
I do, because I am relatively new to this issue, and as a newer member of the Judiciary Committee, and one who doesn't get to attend all of the meetings. So I want to make sure that I'm not heading us down the wrong path or reinventing the wheel here. Clearly, we do have 1310 that could be used as a vehicle for moving legislation forward this session. What I don't totally understand, though, is the interplay between recommendations 1, 2, and 3 in the report, right? Because if what is being recommended is in number 3 is to move forward with the substantive LD 1459, but incorporate the comments of the press. That's not what this says. This says hold a hearing on it, which is really different than move forward with it, right? And so if the goal is to have us actually pass that, if that were, that you think the work has been done on that part, then my question is, does number 3, if we do run forward with it, run afoul of the main Constitution under recommendation 2? And if we do move forward with it, what is left under recommendation number 1 to continue the Criminal Records Review Committee? And I don't ask that sarcastically. I'm sure there is something. I just don't know what it is. So I don't know if that's a question for you, Ms. Axel, or for Representative Talbot Ross, or for Peggy. But that, I think, is the nature of the question in front of us. And obviously it bleeds a little bit into what the substance of 1818 would look like if and when we pass it. But that's what I'm struggling with. And that's what I want to try and truly understand in order to have an opinion about what we should do with the third recommendation in this report. Thanks.
Thank you. Thank you for that, Senator. Ms. Saxel, would you help us out a little bit here?
Exactly the right questions. It is super complex. So from my view procedurally, or in terms of a path forward, this is what I see. We have one piece of the work of the Criminal Records Review Committee that has been more or less done, which is essentially the substance of 1459 with the additional recommendations that have been made in the report. And this committee, I believe, has several options, and one is to import that language and have a public hearing on it to get additional feedback. The other is to, I think, engage with the press and the other potential minority voices there, and do as you will with your committee process. So that's one distinct piece. The next one is the continuing of the commission. I don't have these in the right order in recommendations, so bear with me. But the continuing of the commission, there are still quite a number of issues that remain out there. So, I don't have the full list of the charge in front of us, but I know one of them was what to do with crimes that are now no longer crimes in terms of past criminal history records. That's still outstanding. I don't believe that we have dealt head on with the issues related to sex trafficking that that DA Sarbeck was pointing to either. There are some elements of the recommendations in 1459 that address that, but it doesn't, in my mind, fully address that range of issues for victims of sex trafficking. So there is continuing work, but that's work that, as you point out, would begin after this session and would be prepared to be brought forward for the first year of the next session. Now there's the third piece of the bill, and which is around the constitutionality issue, and there is what I would characterize as disagreement in the field about whether or not the 1459 potentially might be going too far to run afoul of the separation of powers issue. The fact that it is an expanded version, very barely expanded, of a law that was previously in place suggests to me that particular recommendation is probably sound. I think what was the bigger question around the constitutionality was, if we go further and look to really begin to try to expunge or otherwise deal with records like those, like the crimes that are no longer crimes related to marijuana, et cetera, that's where I see the potential constitutional issues raised. So, and I have also heard the MCLU say, and in many public settings, so I feel confident doing this, and I can, Mr. Kadebe can call me out later if I've gotten this wrong, but that ultimately it's going to be for the courts to decide whether or not these are constitutional or not. And so the legislature can certainly act preemptively to try and get a constitutional amendment, but the other option is that call is made within the courts. And so that shouldn't bar us from moving forward. And for us, that's a change of perspective. We have always opposed expungement of records because we've been concerned about it being unconstitutional, but we are increasingly convinced that we ought to leave that issue to the courts. And I know that comes at the cost of the first people involved in those cases, but that is certainly the other path forward. So I stand by the three recommendations of the report, and am really grateful that you gave me time to speak on this because I think this is so important.
Thank you. Are there other questions from the committee for Ms. Saxel? Seeing none. Thank you very much for being with us. Are there other commissioners, members of the committee, I guess, that are in attendance? I don't have that attendance list, but
yeah. Both Judy Meyer and Michael Kabedi, I'm going to move them over. I'm trying.
Okay, I see Mr. Kabedi. Michael, it is Kabedi. Is it Kabedi? Am I saying it properly? I've never asked you, I don't think.
Yep, that's the correct pronunciation.
Okay, thank you. Welcome, and we'd love to hear what you want to say about your report.
Thank you very much. I appreciate it. My name is Michael Kabedi. Feel free to call me Michael. I represent the American Civil Liberties Union, where I'm policy counsel, and served as a commissioner on the Criminal Records Review Commission, along with Judy Meyer and many other wonderful people. I wanted to just say a word about Senator Sanborn's question about whether recommendation 3 would run afoul of the Maine Constitution and how it fits in with the other recommendations. So I think that Elizabeth Ward Saxel couldn't have put it better, that what recommendation 3 does is it revives a law that sunsetted a couple of years ago. And that law for a couple of years gave a certain very small group of people the opportunity to ask a judge to seal their criminal records. What the bill that the legislature killed in the long session, LD 1459, the bill that the Criminal Records Review Committee is asking you to take up in LD 1310, or another legislative vehicle, what that bill would do if enacted is simply expand the sunsetted law that would allow a certain class of people to petition a judge to seal their criminal records. That law, when it was in effect, allowed a couple of dozen people to take advantage of it and seal their criminal records. There is a significant difference between sealing and expungement, or sealing and pardoning. And that's the reason that LD 1459 and the law that sunsetted would not run afoul of the Maine Constitution. I'm not aware of anyone, including anyone from the Attorney General's office, that's made the argument that sealing violates the separation of powers principles of the Maine Constitution. The only arguments that have been made in that vein concern expungement, or the destruction of criminal records by anyone other than the governor. You'll hear from me again when you're in the public hearing for LD 1818. But I'd like to conclude there and thank Peggy Reinsch for the extraordinary research assistance that she provided during our very short time as the Criminal Records Review Committee.
Thank you very much, Mr. Cabetta. Are there questions for the representative of the Maine Civil Liberties Union? Seeing none, thank you very much for being with us. Appreciate that. Judy is here. Ms. Meyer, welcome, and we'd love to hear your comments.
Thank you, Representative Babbage. And with all respect to my committee colleagues, I disagree that the work on 1459 is done. And my minority report, which Peggy was kind to say is a little long, because it's very long, and I won't go into all of it, but there are two major points that make me very uncomfortable. One is that we invited comment on our work and specifically on that bill, and Justice Donald Alexander sent us an 8-page memo, and he outlined a number of concerns about sealing records. He made a bunch of observations and a number of recommendations. We received that memo by email, but we never discussed it as a committee. It was never launched as a discussion or consumed or deliberated. And he is speaking from a level of experience and expertise. We're talking about sealing records that result from prosecution in our courts. And to not hear from a retired justice of some esteem, I think showed a lack of work. But there was so much work to be done, we just didn't have time. The other thing we didn't talk about that's in this bill is the provision that if you want to seal or otherwise make your criminal record confidential, you have to file a motion, go to hearing, and get a court order. This requires, with all respect to the attorneys in the room, people to hire lawyers, and not everybody can afford to do that. Lawyers will not be given to people to do this process. So it creates this level of inequity, I think, that discriminates against people who can't afford to participate in the process. And if we're talking about a process that will give anybody and everybody an opportunity to seal their records and move on with their lives, this bill doesn't provide that opportunity to everybody. It only provides it to people with the means to hire a lawyer. And we need to discuss that before moving forward, in my opinion. So those are the two main points, but I'm happy to answer questions.
Thank you very much. I for one, have not read, Judy, would that be part of the appendices that is available to us online? It is. Thank you. Do we have any questions for Ms. Meyer, the Maine Press? Seeing none, thank you very much for being with us. I appreciate that. Oh, I'm sorry. The chair is back. Yes, Senator Carney.
I'm happy to have you continue to chair as we discuss the report. But I did have a question for Judy Meyer. I really appreciate you bringing up those two issues. And I just wanted to, from my perspective, the committee would have the ability to and would read Justice Alexander's report and really include that in a robust discussion of legislative language, as well as the issue you raised about equitable access to the process. And I'm just wondering if there's a reason why you think that would have to happen before the bill came to the committee.
Well, I think the recommendation is just to bring the bill to a public hearing. But the bill does not have the benefit of having had that rigorous discussion and having those issues aired out. And if they had been, the bill may have taken a greatly different form, a slightly different form, but you would be calling a public hearing on the current language without the benefit of the rest of it. And that feels incomplete to me.
Thank you, Ms. Meyer.
Thank you.
Are there other questions for Judy Meyer? Yeah, that was not a hand, Representative Thorne, was it? Okay. Seeing none, thank you very much for being with us. I appreciate your written dissent. Is there any other person in attendance that I'm not seeing that would like to speak on the report? Mr. Cabetta.
Thank you very much, Representative Babbage. I know I already spoke, but I just wanted to address Judy Meyer's very reasonable comments. The first being that the petition process requires people to have means, and that's a very good objection. We do think that it would be good for everyone who has a criminal record to be allowed to take advantage of the sealing process. But it would be bad to deny some people justice because all people can't have justice. I think that's an argument that everyone can easily understand. To make the perfect the enemy of the good in this situation, I think would be to do wrong by the group of people who can successfully take advantage of this process. And this objection can be addressed through the public hearing process and the work session process. For instance, I mean, I know Maine has a surplus and is debating whether to return that surplus to taxpayers. Well, maybe some of the surplus should be used to hire lawyers for people who don't have means to petition courts to seal their records. That's the kind of thing that often gets added to bills after public hearing. As for Justice Alexander's excellent memo, that can also be part of the legislative record through the public hearing process. I don't think it's necessary to kick the can back to the Criminal Records Review Committee at this stage on this issue, mainly because this issue already took the previous version of the Criminal Records Review Committee lots of months of work. And to add this to the list of things that a next Criminal Records Review Committee would have to review would make its job even more difficult. Various legislators during this hearing have already said how complicated this issue is, how much time it's going to take. This is a bill that's ready for a public hearing, and it can certainly be amended through the process of public hearing as a result of comments like the ones Judy Meyer made, but to pile it onto the Criminal Records Review Committee's list of duties would require much longer than that body will have between this short session and the next legislative session. Those are mainly the comments I wanted to make. Thank you for your attention.
Thank you, Mr. Cabetta. Since I have you in front of me, in reading the report and the charts of the so-called, or maybe not so-called, but equal to a pilot project that ended in 2019. Help me to understand. There were a few denials, but what was necessary for the petition was a preponderance of evidence. And I'm not sure if I understood preponderance of what evidence. I mean, we're not retrying the case. the list of criteria for the petition process is pretty specific. Is that what they're talking about? And there's even an appeal, but it seems to me that it's cut and dry as far as who is eligible to make the petition to seal. I mean, so I just want to try to understand that. It seems to me that if somebody qualifies, there's really not much question except the formality to grant. Is that true or not under the law that was in effect 2016 to 2019?
Yeah, Representative Babbage, thanks for that question. My understanding is that, yes, all that's needed is that you satisfy those criteria. If you satisfy those criteria, you haven't committed a crime since you finished the punishment for your crime. You're within a certain age range. You check these boxes and your record is automatically sealed for a certain very limited class of crimes. That's it. And the denials, as I understand it, are based in facts where one or two or more of those factors were not present. That said, I'll admit that I've never petitioned for someone's record to be sealed. Perhaps DA Sarbeck knows more about it than I do.
Okay, thank you for that clarification. Are there any other comments? Questions? Seeing none. Peggy, is there anybody else that is in the queue? There is not. Does anybody in the committee have any further comments or requests of Peggy before we go forward? I'm sorry for that question, Peggy.
That's what I'm here for.
Seeing none, then thank you very much for the report, and I'll return the gavel to our esteemed chair.
Thank you very much, Representative Babbage, and thanks for taking over as chair while I went to HHS. At this point, we are done with the presentation of the report, and I just want to express on behalf of the committee thanks to Peggy, to chair of the committee, Representative Talbot Ross, and everybody who spoke and helped us understand the report and the work of the committee. And with that, we will move on now to the public hearing on LD 1881. And so I open the hearing and give the bill sponsor, Representative Talbot Ross, an opportunity to introduce the bill to the committee.
Well, thank you very much, Madam Chair, and thank you to all of the committee members for a really robust discussion about the committee report. Good morning. My name is Rachel Talbot Ross. I represent House District 40 in Portland and serve as the Assistant House Majority Leader. I want to just give a Happy New Year greeting to each one of you, and a special warm greeting to Representative Evangelos. It's wonderful to see you today, and I'm hoping that we're able to catch up when it feels appropriate. So Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. As I said, I am Rachel Talbot Ross. I represent House District 40 in Portland and serve as a Assistant House Majority Leader. Thank you for the opportunity to present LD 1818 resolve to reestablish and continue the work of the Criminal Records Review Committee. As members of this committee will recall, and you've just had, again, a very robust discussion about this, the Criminal Records Review Committee was established by the legislature last year. The committee was charged with reviewing the issues involved in sealing and expunging criminal records and exploring options to ensure those who have been convicted of crimes and served their sentences are able to return to their communities without their convictions holding them back from leading successful, fulfilling lives while also protecting and advancing public safety. For your convenience, I have attached a copy of the review of the committee's report to this testimony. I know you all have had it as we've been discussing. The review committee made 3 recommendations, as you're well aware, one of which was to reestablish the review committee in 2022 so that we may continue our work LD 1818 is the vehicle to accomplish that. As we've been discussing, these are really quite complex issues, in large part due to the numerous systems that are involved in it, and they deserve our utmost attention. With the time that we were allotted, we successfully identified resources, we scheduled presentations and discussion to ensure members had the foundational understanding of the issues before us. We worked diligently on those recommendations, which are included in the attached report, but also agreed on the importance of continuing the work after the 130th legislature second regular session. A majority, as you know, of the review committee members voted to support LD 1818 as a way to continue this very important work. The review committee is eager. I think you've seen a sprinkling of that this morning to reconvene later this year following the legislative session. Thank you for your consideration. I would be happy to take any questions you have. Before I close, I do want to just express my sincere appreciation to committee analyst Peggy, and also to acknowledge Jane Overton, who's also with OPLA, for all of the work that they did. I want to make sure that we give recognition to our Senate chair, Senator Donna Bailey, and the work that she was able to do, and her great leadership on this review committee, as well as to each of the members. And I want to thank you for trusting that a committee of 29 people would be able to get anything accomplished. I know that that was part of your debate in letting us move forward. And miraculously, most of that committee members showed up for all of our meetings, and we were able, even by Zoom, to be able to have robust discussion and move forward. So I thank you for entrusting us with this work. And I want to acknowledge each and every one of the committee members for their due diligence to the work. We look forward, hopefully, to continuing it with your approval. Thank you very much.
Thank you very much, Representative Talbot Ross. And I see that there are going to be a couple of questions. Go ahead, Senator Kime.
Thank you. Good morning, Representative Talbot Ross. You had really sort of a basic process question. Just the bill, if it passes, doesn't go into effect until 90 days after we adjourn. So then there isn't really a way for the work to continue until that point, right? So it isn't as if the committee can continue right after we adjourn the second regular session here, if it's April. Am I right in that?
So technically, yes, we would not come back together conceivably before mid-July of this year. As you heard from committee member Elizabeth Ward Saxel, and I think you may recall, Senator Kime, there have been iterations of this committee in the past. And one of those iterations were we informally met for quite a period of time, over 15, 20 members. While we did not have staff support, legislative support, we still informally met just to continue the momentum and really to keep solidifying the relationship building that was taking place between so many diverse stakeholders. So technically, you're right, we would not be able to formally reconvene until mid-July to do our work. But this is a group that is totally dedicated to the work and enjoy coming together informally to continue to discuss these complex issues. But you are right.
So your idea then is that you would continue to meet informally and then wait to get staff support and to do the more formal work of the committee after the bill went into effect?
I don't have the authority to say that that's what the committee would choose to do. I'm just, in the past, that's what we have done, is to continue our work without that staff support in conversation, because the many systems that this touches and the very complex issues, it does require time and space to get it done. So we would not reconvene technically until mid-July if you so choose to support LD 1818.
Thank you.
Senator Sanborn?
Thanks. If there were bipartisan support for the bill, wouldn't it be possible to add an emergency clause so that it went into effect immediately? And obviously, we still wouldn't have OPLA availability until we adjourned, but we wouldn't have to wait until July. Is that a possibility?
Thank you, Senator Sanborn, for that question and comment. I agree with you. If there was a bipartisan support, would definitely support an emergency preamble to this bill. Thank you.
Representative Babbage?
Yes, I actually, Senator Sanborn touched on what I was going to ask, but I will point out that although it's a heavy lift in front of the committee, because this is such important work, and I appreciate the good representative from Portland for bringing this forward. The schedule for this year does provide for an extra 4 months that they did not have last year. So that is an optimistic consideration. Thank you.
Representative Moriarty?
Thank you, Madam Chair. Representative Talbot Ross, the one thing that you and prior speakers seem to have in common in terms of assessments is that this is, first of all, a difficult subject, and secondly, it's very time intensive, and there are problems with time management here. I took a look at the original resolution from last summer, and among the various, the 9 bullet points that the Judiciary Committee identified, examination of separation of powers was not one among them. And I wonder, with reference to committee recommendation number 2, what your thoughts are in terms of deferring your time and analysis on separation of powers issues and focusing on those which were itemized in the resolution.
Thank you, Representative. I think that issue inevitably is part of the foundational work to move forward, and we would there would be no way to avoid pursuing more information on that and more debate on that should the committee be so fortunate to come back together. In hearing the debate earlier this morning from this committee, it sounds like it would be welcome territory to explore as well. And so in coming back together, I could easily see the committee adding that as one of the tasks to what is already spelled out in the original bill.
Thank you.
Representative Thorne?
Thank you, Madam Chair. Representative Talbot Ross, it may be an oversimplification, and I had a couple angles so I can wrap my head around this. Is 100% agreement the goal to accomplish what you need to accomplish from all participants on the committee?
Well, thank you, Representative. Good morning. That has not been an explicit goal of the committee. With 29 very diverse stakeholders, if you will, and participants, I'm not sure that that would be possible on any subject. But certainly it is consensus to bring forth so that this committee of jurisdiction would be able to then adequately debate and hear from members of the public and others about a particular position. But the goal, from my perspective, is not 100% buy-in. It is to debate and to come up with the best public policy that we can with absolute respect to maintaining and advancing public safety, respect for the First Amendment, respect for those individuals, human beings who want to get on with their lives and to not be imprisoned for life due to a criminal history record. But the goal is to agree to move forward in some fashion in the best interest of the public.
If I may, a follow-up question, Madam Chair.
Okay.
Thank you. Oversimplification on a scale of 1 to 10, as the bill sponsor and chair, where do you feel you are in this to hand it over to the Judiciary Committee?
Thank you, Representative. If you mean by this, we're talking about LD 1818.
Yes.
We're in excellent, I think we're in very, very good position. I think that there is a desire, a need, a feeling of real responsibility to carry this work on. We knew that the time limitations were only going to be able to produce so much. But as I said, in a committee of such of size, we had great attendance. Everyone showed up. And I think that there's overwhelming support for us to continue our work. And if possible, to do so right away. If not, once the 90 days kicks in after adjournment. But in my humble and you asked for simple opinion, yes, there is a great deal of commitment to this work to continue by the members who've currently been serving on the review committee.
Thank you for that.
Committee members, are there any other questions for the bill sponsor? I would just like to follow up on your last statement, Representative Talbot Ross, that it is really gratifying and amazing that these 29 members of the committee who've brought so much expertise and worked so hard are eager to continue the work. And that speaks a lot to, I'm sure, the leadership and the dedication of everybody on the committee.
That's very kind of you. Thank you very much, Madam Chair. And one last wave of appreciation to Peggy, who just did an enormous amount of work. And I know you all are very proud to be able to work with her and honored to work with her in your deliberations as well. But I wanted to give one last thank you to Peggy for her work.
Thank you very much.
Thank you all very much.
And now Representative Babbage, did you have another question for the bill sponsor?
I did want to say to Representative Talbot Ross that not only was the report very interesting and we should applaud all of those stakeholders and so forth to be part of it, but I was also pleased with the people you brought before the committee to testify and the substance of what they could bring to that. I know that you were short on time and didn't have the discussion, which I wish had happened a little bit more, but I just want to applaud the process and certainly support this going forward next summer. Thank you.
Thank you, Representative Babbage. And with that, we will move on to first to those who wish to speak in favor, and then opposed, and then neither for nor against LD 1818. Before we do that, I don't know in my absence whether committee members who joined a little bit after we had done committee introductions have had a chance to introduce themselves. And if you have not introduced yourself, could you please do so now and just go ahead and do introductions, since I don't know who to call on.
I guess I'll just do it. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a small part of Madison.
Thank you. Anyone else? Go ahead.
Hi, I'm Representative Laura Libby. I represent Auburn and Minot in District 64.
Thank you. Does that cover everyone? Looks like it. Okay. So now I'm turning to those who are in the attendee portion of the meeting and asking anybody who would like to speak in favor of LD 1818 to please raise your electronic hand and to keep it raised until after you've been brought on to the panel. Okay, we'll begin with Elizabeth Ward Saxel and then Michael Kebeda.
Good morning again, Senator Carney, members of the committee. My name is Elizabeth Ward Saxel. I'm here on behalf of the Maine Coalition Against Sexual Assault, the organization which represents and serves Maine's sexual assault support centers, in strong support of LD 1818. As I previously noted, I've served on this commission and on previous iterations of it. And continue to think that it's one of the greatest hopes for meaningful consensus around criminal justice reform. There are all many of the people at the table who are needed in order to come to the kind of consensus that we need to come to before we bring these complex issues in front of your and other committees. And so I look forward to continuing to engage in these conversations, and am grateful for the support of this committee in the last iteration, and hope that you will continue to support this group continuing. Happy to answer any questions you might have, and thank you for your time.
Thank you very much. Committee members, are there any questions for Elizabeth Ward Saxel? Not seeing any. We appreciate you appearing before the committee twice today. Thank you. And next we'll hear from Michael Kebeda from the ACLU Maine. You may proceed.
Thank you, Senator Carney, and distinguished members of the committee. Hello again. My name is Michael Kebeda. I'm Policy Counsel for the ACLU of Maine. We are a statewide organization committed to advancing and preserving the rights guaranteed by our state and federal constitutions. And on behalf of our members, we urge you to support this bill because it would continue a very important process to free Mainers from the debilitating unintended consequences of criminal records, extending the promise of our Constitution to all people in our state. You are aware of the problem of the unintended consequences of criminal records when 2 sessions ago you supported LD 764, and last session you supported LD 2086. The first bill established the Criminal Records Review Committee, a bipartisan group that included lawmakers, prosecutors, law enforcement, civil liberties advocates, survivors of sexual trafficking, representatives of the judiciary, advocates for survivors of domestic violence, and still more voices from an extremely diverse array of backgrounds. The second bill extended the life of that group. This bill would give the same group another lease of life. The ACLU has been part of this group since October of 2019. And soon after beginning its work, the group found that the cost, logistics, and unintended consequences of sealing records posed very significant challenges, challenges that the group, with its diversity of skill and perspective, still lacked the time and resources to solve. As you heard from your committee analyst, the latest iteration of the group started its work on October 18th and concluded its work less than 2 months later on December 16th of last year. It generated 3 recommendations, but barely scratched the surface of record sealing. As you heard earlier from Elizabeth Ward Saxel, automatic sealing of Class A, B, and C crimes, or consequences for entities that illegally share sealed records, vacatur, which was the dream of the late D. Clark. These things were left for another day. Almost all of the group's meetings were consumed with presentations. We learned that the state of Maine, like many other states, has a Byzantine system for storing criminal records. We hardly discussed substantive options to redress the many unintended consequences of these records. As Commissioner Judy Meyer said, we received certain memoranda from retired judges that we didn't have the time to discuss. This bill would allow the group to continue building on the work that went before it. We urge you to vote ought to pass and help Mainers move on with their lives after they've done the legislatively prescribed punishment for the crimes that they've been convicted of. Thank you for your time and attention. Happy to try to answer questions.
Thank you very much. Committee members, any questions? Not seeing any. We appreciate you speaking to the committee on both the report and on this resolve.
Thank you.
And now we'll hear from Judith Meyer. You may go ahead with your testimony.
Thank you, Senator Carney, members of Judiciary. My name is Judy Meyer. I'm Vice President of the Maine Freedom of Information Coalition. We're a nonprofit that works to broaden knowledge and awareness of the First Amendment of state laws aimed at assuring public access to government proceedings and records. And I'm here today in full support of extending this committee work. As we discussed during the committee report presentation, we were given 9 specific duties and we met for just 15 hours. It just was not enough time to really dive into the issues. We spent nearly all of our time, as other committee members have told you, hearing from experts and advocates and interested parties, reviewing laws in other states. And in between meetings, we got volumes of additional reading. So there was an enormous amount of information, a truly reflective learning process, but very little time for consequential discussion. And if the purpose of sealing public records is to give people an opportunity, people who have been convicted of Class D and E crimes, an opportunity to distance themselves from those convictions, we did not review as a committee what those crimes even are or what the potential consequences of shielding access to them may be. We heard from a number of experts talking about the difficulty of managing criminal records and the hurdles that would rise if the legislature moves to seal certain criminal records, but we didn't talk through the options to manage those records, nor do we develop options to manage them as we were tasked to do because we didn't have time. We have discussed 1459 during the committee report. Again, time was the enemy here. We didn't have time to walk or talk through the language of that bill in any detail. We didn't have time to read Justice Alexander's memo. And this was a concern when Judiciary moved this bill to create the Records Review Committee forward last year. There were a number of you who expressed concern we wouldn't have enough time, and that really did create our reality now. And I will say our chairs, Senator Bailey and Representative Talbot Ross, kept us focused and engaged. It really was a very, it was a wonderful intellectual experience, I think, for everybody, but we just didn't get the opportunity to really reflect on what we learned. We learned so much, and now we have this knowledge. We're prepared to go forward. I do think there is a path forward to seal some records. There was great consensus in the committee to do that. And so I would ask that this committee return the Records Review Committee back to its work and let it continue on that road. And I am happy to answer questions.
Thank you. Committee members, any questions? And I am not seeing any. Thank you for your contributions on this bill and on the report.
Thank you.
And next we'll hear from Andrea Mancuso, and you may begin.
Thank you. Good morning, Senator Carney, members of the committee. My name is Andrea Mancuso. I'm here on behalf of the Maine Coalition to End Domestic Violence in support of LD 1818. As you've heard this morning, conversations around this topic held over the last several years have highlighted and underscored both the great energy in our communities to engage in the work and also the complexity of the undertaking. MCDB and our member programs strongly support the continuation of this conversation with the hope that this is the path that will result in thoughtful, positive public policy changes, and that continuing broad stakeholder engagement in both the conversation and the decision-making will result in a really good product. Having participated in both the last committee and the previous iteration that you've heard a little bit about this morning, I would just underscore that time is the element that this group really needs to put some thoughtful recommendations before you, and to the extent that you are able to really give us a large window of time to do that work. I agree with Representative Talbot Ross that we're unlikely to get 100% agreement on every minute policy decision. Some of that will have to land back in your laps, but I from the conversations that have happened in the group, I do think that there is a way to get significant majority support around many of the issues that this committee has tasked the review committee with grappling with. If we had time for thoughtful engagement and discussion, I think you'd see some thoughtful products coming out of the group that you've put together. So MCDV has been participating and would be delighted to continue participating if that's the committee's will, and I'm happy to answer any questions that you might have.
Thank you very much. Committee members, any questions? And I am not seeing any. Once again, thank you for your testimony here today and for your participation on the committee. We appreciate all your hard work. And I'll just turn to the attendee space and ask once again if there's anyone who wishes to speak in favor of LD 1818. Please raise your electronic hand. No one has. And if there's anybody in the attendee space who wishes to speak in opposition to LD 1818, please raise your hand. No hands up. And finally, if there's anybody in the attendee space who wishes to speak neither for nor against this legislation, please raise your electronic hand. And again, I am not seeing any raised hands. And so with that, we will, let's have a committee conversation about, is there any additional information that we would request Peggy to bring back to us for the work session? I see two hands up. Representative Babbage, yours was up first. Did you have a request for information for the work session?
I don't. I did want to just make a comment, if I could, just brief, but one of the reasons that I'm very supportive of going forward with this.
Representative Babbage, that sounds like a work session comment, but
okay.
Let's get to request for information first, and then we can come back to you. Requests for information, Representative Moriarty.
Thank you, Madam Chair. Several requests. First, I may be whistling in the dark, but I think it's important to know whether or not the current committee still exists or whether it has to be reappointed. And a decision from on high somewhere within the legislature, but I think it's something that needs to be addressed. Secondly, we need to know whether the committee, if the committee has ceased to exist, can it nevertheless continue to meet on its own during the second session and make some progress? Third question, what are the pros and cons of an emergency preamble? At the very minimum, it buys the committee 90 days of additional time to do its work, and that could be significant. Fourth and final question, the bill provides a report date of November 2, 2022, which is obviously just before Election Day. Is it important for legal purposes or for continuity purposes that the committee report before Election Day as opposed to a month after? Those are my questions.
Thank you very much, Representative Moriarty. Other information requests, committee members? Not seeing any.
I do have one.
Go ahead, Representative Babbage. I was just going to call on you. Go ahead.
Yeah, thanks. Regarding a committee request, I would ask Peggy. Now, I haven't looked at the appendices to this report, although I spent a lot of time with the report itself. But the report mentioned I don't know if it was admiration, but relevant information and policies by the states of Colorado, Massachusetts, and a third, and I've forgotten the third state. But I wondered if in all that work that Peggy did for the committee, and Jane Orbiton, if they had a side by side regarding those states for us to look at. Do you know that?
Okay. And then Representative Babbage, did you have another comment or are you
Yeah,
gonna?
okay, thank you, Chair Carney. I just wanted to say that I am enthusiastic about going forward with 1818. And I appreciate the committee's willingness to do so, because this has substance. These decisions are not easy. From a personal perspective, I see my job on judiciary is to really assess pros and cons and find a path forward that is good for the people of Maine without doing harm. And when task force show us that they've had the tough discussions, even with dissent, but that gives this committee, I think, fodder for greater understanding. If a task force should come in with unanimity without the report including dissent, then I find that it falls on me to find the potential problems and consequences, which is a great burden for judiciary to deal with in the short time that we do with all that's before us. So the task force going forward and having these tough discussions and then reporting them out is a great benefit to this committee, and I appreciate them willing to go forward to do that.
Thank you, Representative Babbage. And with that, we will close the public hearing on LD 1818. And again, thank the sponsor for bringing the bill forward. And we are done with our committee work this morning. We will return at 1 o'clock for work sessions on LD 233 and 903. And I think that we've received some handouts and amendments via email from Peggy on 903. So with that, everyone, we'll see each other in about an hour. Thank you.
Thanks.
Bye all.
Steve, your mic is hot, Steve.
Yes,
Okay.
thanks, Heather.
Hello, committee members. It is a few minutes after 1, and it looks like we are all returning from our lunch break. Give our colleagues just a few more minutes to rejoin the committee meeting, everybody. All right, let's start our afternoon's work today. We've got 2 things on our schedule. We have work sessions on LD 233, juror information, and LD 903, foreign money judgments. Before we get to those, I just wanted to speak for a moment about LD 1862. That was listed as being scheduled for a work session this afternoon. We're not going to take up anything having to do with 1862. We have been requested to re-refer it to the Criminal Justice and Public Safety Committee, but I want to take another look at the bill before we move forward with that. So we'll take that up another day. So today we'll just be doing work sessions on 233 and 903. And with that, I will open up the work session on LD 233. And that is sponsored by our colleague and chair, Tom Harnett. He's not able to join us this afternoon, and so we'll begin with Peggy's bill analysis.
Oh, and here's the really embarrassing part. I never did a bill analysis for this bill last year, but the bill was heard last year, and I had it right in front of me, and it requires the court to make the names of prospective jurors and the contents of juror qualification forms available to attorneys and their agents and investigators and the pro se parties at the courthouse for use in the conduct of voir dire examination. Right now, that access is at the at the discretion of the court. And then the bill also, because this was a pandemic bill, the court shall also provide this information electronically to the attorneys and their agents and investigators and the pro se parties at their request. And the testimony was that it was very difficult for attorneys to get that information in order to prepare for trial. And there were several folks that, let's see, the Maine Association of Criminal Defense Lawyers spoke in favor of the bill. Maine trial lawyers spoke in favor of the bill. The Criminal Law Advisory Commission spoke neither for nor against, and the judicial branch opposed the bill, at least as written. You had tabled the bill to collect more information. And also I believe that there was some thought that because the judicial branch was working on more electronic access rules for records, as well as, going through the shutdowns and pandemic concerns, access to the court that way. So I think Amy Quinlan is here in, you usually see Julie Finn. Julie Finn is not available today. So Amy Quinlan from the courts, I believe, is ready to respond with any questions that you had asked the court last year, and respond to any questions you may have today. But I know that Julie Finn at one point had talked to the judges, and Anne was ready to respond at the end of last year, and we ended up carrying it over.
And Peggy, just before we bring Amy Quinlan onto the panel, did we receive anything in writing from the judicial branch last year?
Yes. You had, it was at the public hearing.
Oh,
and
okay.
It was on the AOC stationery.
Yeah, but then in subsequent, like after the hearing, when we had asked some questions, we haven't.
I don't believe so.
All right, great. Thank you. And so Amy Quinlan, I'm going to bring you from the attendee portion of the meeting onto the panel. Hello and good afternoon. Welcome to the Judiciary Committee.
Thank you, Senator. Thank you, members of the committee. I really appreciate it very much. The opportunity to speak with you. I don't know, I want to answer your questions. I don't know that I have the list of questions that were posed last year, but we have talked about this quite a bit. So hopefully I can answer the questions that you have for me today.
Thank you. I'll start out with a very basic question, which is, can this be implemented now as the bill is written? Can the information be provided electronically?
So it cannot. We are, I think, in the process of implementing a system for electronic e-filing and electronic case management. And we did investigate the module that would permit the transfer of this information, but it is quite costly and very cost prohibitive. So I will say to you that the goal of the judicial branch is to make information available electronically, but we cannot do so at this time. And I just want to, I believe when Julie testified last year, she also provided you with copies of, or a copy of what the juror questionnaire looks like. Our concern is if you take a look at that questionnaire, jurors, which are the bedrock of our system, are required to answer very personal and confidential information related to financial concerns, information related to medical concerns, and more. And so the transfer of that information electronically has to be done in a way that protects that information. We typically make that information available to counsel at the courthouse. And we understand that there have been concerns by counsel being required to come into the courthouse to a room and to review that information in the courthouse while the pandemic is ongoing. but we don't have a way electronically at present to transfer that information with all of the protections that would be required to do so, given the sensitive nature of that information. So we want to move in that direction. We want to do that not just for juror questionnaires, but other things as well. And we're working to do so, but we don't have that capacity at present.
Currently, if an individual who doesn't have any connection to a case for which a jury is going to be chosen comes into the courthouse, do they have access to that information, or do the clerks control it?
They do not.
Can you describe for us a little bit what the current controls or limits are on access to that confidential financial and medical information?
So the parties that are involved in that case, typically the attorneys would request to see that juror questionnaire, contact the clerk's office, and they'd be set up in a space to be able to review that information in the courthouse.
And are they permitted to photocopy it or otherwise duplicate it?
They are not. They can take notes, but they're not permitted to photocopy it.
Are they allowed to take cell phone pictures of it currently?
I don't believe so. And I actually should check to make sure that they cannot copy it. I don't think it's so much that an issue of the attorneys having access to it and having it within their files. It's the actual transfer of that information and making it sure that it gets to the appropriate party, the person that's authorized to be able to look at it. So the person that's involved in that case.
Mm-hmm.
And the other thing I just want to add is that when the jurors come to the courthouse or are asked to serve, that the protection of their confidentiality is utmost on their mind. We're often asked, well, if I'm answering these questions, what are you doing with this information? So the ability to be able to have jurors come and willingly serve is contingent on our ability to assure them that the information that they're providing is only going to the appropriate places, and that it's not just going to be let out there, able to be accessed by whomever, that the controls of that are tightly held, and that it only gets to those who are involved in the case as it should, and not beyond that.
Thank you. Committee members, I kind of jumped in with a bunch of questions before inviting all of you to ask questions. Are there questions for Amy Quinlan? Go ahead, Representative Babbage.
I guess I'm already off. Thank you. Thank you, Madam Chair. Good afternoon.
Good afternoon.
Ms. Quinlan, if you could help me to, I think if I recall, prior testimony, and you can correct this if it's wrong, that the courts may vary somewhat, but that officially photocopying with or taking a picture with a cell phone is not permitted, but that supervision of that process is more one of trust than of enforcement. Is that right?
I think that is correct.
If I remember, Julie Finn, I thought, brought up an issue of pro se litigants. I'm not clear in my mind as, do you have a concern with pro se litigants and the electronic process? And what would that be?
Absolutely. So, it's the dilemma that we have with electronic information, period. We want to make sure that we are doing it appropriately, that emails that are sent out are encrypted and sent to appropriate addresses. It just makes it more of a challenge to be able to share that information electronically. There are systems, and the one I speak of, the Odyssey system that we did look into, the Odyssey system is the one that we have purchased and are implementing for e-filing and case management. They have, as I mentioned, a juror module that puts into place some controls with regard to that makes sure that the information that is being sent is encrypted, that it's password protected and beyond. Whether it goes to pro se litigants, whether it goes to attorneys, folks involved in cases where there's a jury trial are entitled to that information, but not beyond. And so we have to be careful. It's not just a matter, I guess the point is, it's not just a matter of that information being scanned and sent out by email. There needs to be, it's more than that. And even if it were, we're often bringing 200 plus folks into a courthouse, juror questionnaires, that the questionnaires can be lengthy. Scanning and emailing out that information is also an issue of resources, but that's really a secondary issue. The primary issue is the one that I've addressed first, which is the confidentiality and making sure that that information goes only to those who are entitled to see it.
Thank you. I have one more, Madam Chair, but I'll wait if you want, or it's not a significant one, but.
No, go ahead with your second question.
Okay, thank you. I want to just ask that should an attorney not honor confidentiality of these jurors, what is the penalty? Is it only one through, like licensure by the bar, or I'm not sure what that would be, or is there an actual Class E violation?
I certainly would be a matter of ethics and bar licensure issues, I would think. And I can't speak to how the particular judge in a case would handle that. But there are ways to address that. And that's absolutely true. But the problem is once the information is out there, it's out there. So what we're trying, and then there's no fail safe, as you mentioned, we're not, when an attorney is viewing this information, we're not looking over their shoulder. There was always trust. I mean, these are professionals that, are doing their jobs as they should. So that's not really the issue. It's more of when things are going or being transferred electronically through a system, that all of the protections, the encryptions and the like are put into place to be able to handle that information as it goes through electronically and is transferred. That's really the most important piece to that.
But so if a pro se defendant should violate that confidentiality, they wouldn't be held to an ethical standard in the same way. So there is no recourse or penalty involved.
Well, there wouldn't be a licensure one. Again, I can't speak to how the judge would handle that.
Okay.
But a pro se litigant who is handling a jury trial, which would be not a common occurrence.
No, I understand.
Yeah.
Thank you, Madam Chair.
Thank you. Go ahead, Senator Sanborn.
Thank you, Madam Chair. So my question is that there's two parts to the bill. And one is about this electronic transfer of information, which I hear you saying very clearly would be very expensive for the judicial branch to accomplish at this point. But the other piece is about removing the discretion of the court to deny access to attorneys, their agents, and pro se parties to see these juror questionnaires. And I'm wondering if, because you actually stated in your answer to a different question a bit earlier that that the attorneys and pro se litigants do have a right to see those qualification forms, but it turns out in our statute right now they don't. It's at the discretion of the court. Is that something that the judicial branch has an opinion on as to whether we should remove that discretion?
If I said that it was a right, and then I misspoke, and I apologize. And no, we don't have a position on that.
Yeah, thanks.
That's a policy choice for you all. Yeah.
Peggy, could you please screen share the bill just so that we can see the two-part nature of the bill that Senator Sanborn just asked Amy Quinlan about? Thank you.
So I believe the two parts are changes it from the discretion of the court to the court. Those juror qualification forms must be made available. And then the second piece is making them available electronically.
Thank you. Committee members, does anybody, I really appreciate you showing it to the committee as a whole, Peggy. Committee members, does anybody have questions for Amy Quinlan or for Peggy about this, the two-part nature of the bill? Amy, do you see any barriers to the change of may at the discretion versus must? I mean, it seems to me like that is information that if the courts are going to collect it in connection with use in jury selection, that they should indeed be available to the litigants. Are you aware of any barriers to mandating that it be available?
I just would say that there is during the pandemic, the spaces that are available in the courthouse to be able to provide that information are just small, and we're making do as we are trying to maintain social distancing. So pandemic conditions are just make it more difficult. I'm not going to say it would be a barrier to it. It just and we're doing it now. But I just want to mention that because I think that has been an issue that's been raised. So,
thank you. I see some additional committee member hands, and Representative Babbage, I'm not going to start with you. We'll, that Representative Reckett, you had your hand up initially, and then we'll Representative Moriarty, and then we'll reach you, Representative Babbage.
Thank you. The reason I took my hand down after the first two questions that Representative Babbage asked is his second question was my original question. So I got answered. But now that I look at the bill, I'm really concerned about removing the at the discretion of the judge. I'm very concerned about pro se litigants. I'm really concerned about battered women caught in this mess. And I think that I'm more inclined to trust that the judge will have whoever they are, will have at least a handle on whether or not there's some kind of significant danger around this. So I'm not, my opinion is that I'm not real crazy about this bill after we've discussed it here for a bit. And I don't know a way that it could be fixed that would make me feel better. So I just be quiet then, I think. But that's basically what my concerns are. And so that's it.
Yeah, thank you for sharing your concerns. Representative Moriarty, go ahead.
Thank you, Madam Chair. Ms. Quinlan, some years ago when I did a little trial work, we used to frequently speak of juror questionnaires. And my impression at the time was that any attorney representing a defendant or a party, I should say, coming into approaching a trial had the right to examine questionnaires. Is there any distinction between a juror questionnaire and a juror qualification form, which is the phrase used in the statute? Or are they the same thing?
I believe that they are the same thing.
And has it not been the practice then that counsel are not automatically entitled to see qualification forms? Do you know how the court exercises its discretion?
So I cannot speak, I'm not familiar with that process here. I can certainly report back to the committee on that. I will tell you that I'm also an attorney, and my experience has been that they are typically provided. So it would be only in extreme circumstances. And as pointed out, there are circumstances where that becomes an issue. The reason why we were providing the nature of the information on the form is for you all to be clear about what the level of confidentiality types of information that are included on those forms, so that you're aware of that and what's contained when you make your decision about this legislation.
Okay, I've got it. Thank you.
Representative Babbage?
Thank you, Madam Chair. Excuse me. I'm following along on the same line of questioning, just to try to clarify in my mind. It would seem to me in the voir dire process, if the questionnaires were not examined, that would almost be a shortcoming on the part of the attorney's practice. Are you aware of a criteria for denying access, or even incidents of that happening? You mentioned space, but would a pro se litigant be denied in a case of where domestic violence might have been an issue? Or I'm wondering if it's a matter of the facts of the case that would be a currently permissible reason for denial of access, or if there are none and it's more spatial and so forth. Thank you.
The space really is just the barrier for the logistics of it. That doesn't speak to the discretion that the judge would impose in making a decision on viewing those questionnaires. There is no laundry list of factors that would be considered. It would be very particular to that case. I can't speak to instances, all of the things that have been mentioned today. I couldn't tell you under these circumstances, that's really case by case. But given the nature of the information, you can see that those decisions would be made very carefully if circumstances presented themselves that there was a question that information would not be maintained confidentially as it should be, and as we assure the jurors that it is.
If I may follow, if a pro se litigant were denied access, is that not? Well, I don't know. Is there an occasion where a pro se litigant would be denied access, but the prosecution would still have access?
I don't know the answer to that question, but if it would be helpful, I can certainly do some digging on the parameters of how those decisions are made. I don't know that I will come back with a laundry list of things, but if there are particular questions, and maybe this is what you asked Julie about, and I'm just not familiar, so I apologize. But I can certainly follow up on that for you if you'd like.
In my line of thinking is I'm searching for justifiable criterion for denial if we're going to entertain this change. Thank you.
Yeah, I do think it would help give us context for seeing what the policy choices are here. Representative Evangelos, go ahead.
Thank you, Madam Chair. Madam Chair, forgive me, but I'm a little confused. And when it's appropriate, I'd like to hear from somebody from the defense bar to explain what this means in terms of their client base and everything. I'm just feeling a little lost, and I want to hear from one of our panelist attendees, please.
Yeah, so we were just about to actually bring in Walter McKee from the panel, but so that will happen momentarily. Committee members, are there any questions for Amy Quinlan before we hear from Walter McKee? No, not seeing any. Okay, Amy, are you okay staying on the panel? Because there may be some back and forth dialogue that would be helpful to the committee's process.
Absolutely, Senator.
Thank you.
Good afternoon.
Hi, Walter McKee. Welcome to the Judiciary Committee. And could you clarify, are you here on behalf of main trial lawyers, MACDL, or on your own behalf?
For MACDL, I actually provided testimony when this bill came up in the previously, so I'm here on behalf of MACDL.
Excellent, thank you. And can you give us some feedback? I know you've been listening to the conversation.
Thanks a lot. And I've got a little bit of experience in this area. I've tried over 200 civil and criminal jury trials. So I picked a jury in every single one of those cases, and those are just my cases. When I was a very new attorney, I would do those with other attorneys. And I've certainly picked juries that didn't go to trial too. So I've kind of been around the jury selection block a bit. And so I appreciate you getting maybe to get a little bit of practical information from me on this. I think the concern that was raised last year, and we kind of talked about, was kind of the technical part of it. And as I was reviewing my prior testimony, I think I was a little cheeky, but maybe accurate when I said that the technical complexity of doing this is, in our view, not overwhelming. Our view, and this was, I believe, shared by the trial lawyers, and I'm certain that Representative Moriarty can appreciate that his partners are in trials with me many times, where we would appreciate having the benefit of this information electronically. These are jury questionnaires. These are standard questionnaires. You've seen them. I would suggest to you that the information on there is information that is somewhat publicly available. With a little bit of searching, I could probably get all of that information and more about all those jurors, perfectly legal through public databases. But the idea here is we have about 200 questionnaires. They're all stacked up and they're in a binder. So when I would go over and pick a jury, as anybody would, I would that morning or sometimes the week before, depending on my schedule, simply open up the binder and they'd have these pages. And I would go through each and every one of them, take notes. Before I got that, though, I would actually have a summary sheet that the court prepares: name, town they live in, and occupation, and date of birth. Kind of gives me a rough guide to take notes from. And I'll just page through those one after the other, take notes. And then when we do pick a jury, I've got a rough idea because I've gone through all those questionnaires. Taking a stack of 200 pages and putting them in one of the court's scanners, just like we have here at my office, it probably takes 10 minutes, to be generous, and it's converted into a PDF. That PDF is highly securable. We receive confidential information from district attorneys' offices, the U.S. Attorney's Office, a whole host of other places that simply provide password protected PDFs. You have to have the password as the lawyer. And we open those up and use those, and then we don't share that information with anybody else. So I hear where the branch is coming from. Everything is a bit of a change. They're involved in whole major processes with respect to all kinds of electronic records. But this seems, from the defense lawyer's perspective, and I think from the trial lawyers as well, to be kind of the low-hanging fruit of electronic information. We get this kind of information every day. It sits in our files. And so our view was that this could be done with a relative amount of ease, recognizing really what we're talking about here is stack of paper into a PDF and secured. In response to the question about violation, the violation for a lawyer, of course, there is an ethical issue there, and they will be reported to the Board of Overseers. But this juror confidentiality comes from a judicial order through the branch, and the branch has all kinds of orders that people have to comply with. And a violation of that order is a contempt of court. Somebody can go to jail for up to 6 months, whether it's a lawyer or a pro se. So there are real penalties here for just about everyone. I've never seen a pro se denied access to juror forms. I would suggest that the part of the bill that says that the judge must provide them is consistent with constitutional obligations for a fair trial. I have seen courts right over here in Kennebec County in particular, when a pro se wanted to look at the questionnaires, the judge just set a little different procedure. Clerk would be there, there'd be other people around, just to make sure everything was fine. Not because they were suspicious, but because they were sensitive to that. And so I think having the word must in there meets the constitutional obligation. At the same time, still allows the judge to put restrictions on that. So you must allow them access, but the judge can say, well, here's the kind of access that we're going to do. And that's what happens in the practice as well. And so I in terms of cost and so on, address those issues, violation, the constitutional obligation to provide these. I think we just wanted to be able to have this in a way separate from COVID that was far more convenient and enabled us to really kind of look at this information, digest it, think about it, do follow-up analysis of jurors, part of our work as defense lawyers and trial lawyers on both sides, prosecutors, defense, plaintiffs, and defense, to have the full measure of information so we can make the best decisions about what the most fair jurors would be in any individual case. So thank you for letting me speak about that. I'm certainly happy to ask any questions. As I've said, I've been around this block a couple hundred times.
Thank you very much for your contributions, and let's see if committee members have questions for you. Are there questions, committee members? Representative Evangelos, go ahead.
Thank you, Madam Chair. Walter, given the way we're being forced to operate now because of the constraints around the pandemic, I assume that dealing in person and all of this stuff in the courts is going to be somewhat restricted for a while. Wouldn't this small piece of reform actually help, expedite and move the process along?
It is. The jury trial process right now, of course, we haven't had a lot of them, but we have had some very slow because of the way that it has to be done with distancing and limitations of numbers of people actually in the courthouse. And so this piece speeds what's already a slow process along. We're really able to only do a very few cases, if we can at all, jury trials each month in any individual county. And I've been to just about every county. Well, I've been in my career, and certainly in the last couple months, most of them. So that part there, having that in advance, will certainly speed things up and at least allow us to have a few more jury trials to deal with just a mind-boggling backlog of criminal and civil jury trials still set to take place.
Any follow-up, Representative Evangelos? No, okay. Go ahead, Representative Libby.
Thank you, Madam Chair. Thank you for being here today, Mr. McKee. My question is, I'm looking at your written testimony, and you stated that information about what is asked on the form, and I'm just trying to figure out, can you as an attorney view the entire 19 question survey, or are there some pieces that are left off? You can see the entire survey?
Yeah, it's everything. And sometimes there are follow-up special jury questionnaires, because there's race involved in the case. I don't think this bill deals with those. I think those are very, very sensitive because of the nature of that. You're expressing actual opinions. This is the basic background information, which I don't think contains financial information. That was mentioned before, but I don't think it has any financial information. But it certainly has dates of birth, or even law enforcement occupations and stuff like that. But we get it all 19.
So follow up, if I may, Madam Chair?
Yes.
I guess you brought up a question I didn't know that I had then. So would this change to statute, and perhaps you're not the person to ask, but would this change to statute allow for those additional questionnaires to also, would it mandate that those would also fall in the same system, or are those treated differently in the law?
No, I think as the judiciary branch representative indicated, this is a specific form. We know it when we see it. It's I can't remember the actual name of it as defined there, but that's just this form. Those others are off limits, and those are also often done day of. So you're really not going to getting electronically doesn't help you anyway, because we're kind of doing them on the fly at the courthouse that day.
Thank you.
Any other questions for Walter McKee? Go ahead, Representative Reckett. And then we also have Justice Alexander available, and he may also have some thoughts to contribute to this matter. And so let's hear from Representative Reckett's question, and then we'll move on to Justice Alexander. And we're not able to hear you, Representative.
Mr. McKee, your remarks have calmed my fears. But I really am curious as to whether there have ever been ethical violations filed on this issue to the bar. Do you know?
I mean, I don't know. I kind of track those because we're in the business. So I haven't seen that. And maybe that's because, lawyers, they honor the confidentiality of that process. I guess it could happen and they're reported. Maybe that's the other part. But I've been around. I think we take this pretty seriously. We get the questionnaire, they stay there. You wouldn't take those out of the courthouse. You really have no reason to. You just want to see them, get the information, pick your jury. As Alexander knows, that process happens. You get there at 8 o'clock in the morning sometimes. You roll through the questionnaires, you pick the juries, and it's not a perfect process, but that's kind of the way it goes right now.
Thank you.
Let's see. Any other questions, committee members? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Mr. McKee, a very quick question. We've spoken this afternoon about attorneys and pro se defendants. What about represented defendants? And to illustrate, if you had a client who insisted on viewing the information together with you and perhaps copying the information for his or her own purposes, what would attorneys do in that situation?
Well, I think it's almost universal. I mean, first of all, if they wanted to have access to it and look at it, I think they probably would be allowed to. That is the information that's available. I can't say I've ever had that happen, and I've had some difficult clients that wanted to be involved in every single piece of it. But this is one that I, and I think most everybody else I know of, would encourage them not to be part of it. If you are signing something saying, look, especially if you're receiving this electronically, you will provide this information to no one else at all. You will keep it in your office. We're subject to all kinds of different protective orders in civil cases and so on about, the restrictions on dissemination, can't leave your office, can't be done, client can't review it unless in your actual presence. So number one, I'd probably encourage them not to do that. Jury selection is a little bit of an art, as much as it is, should be otherwise. I don't think a client really can really be helpful in that process. However, they should definitely know the names of the people and where they're from, because invariably they may know them because, oh geez, I live in the town with that guy. I know that my next door neighbor. That kind of information is provided, and it has to be. Otherwise, you don't know if they know the defendant one way or the other.
Okay, thank you.
Representative Babbage.
Thank you, Madam Chair. This is a quick one from Mr. McKee. Relevant to this process, I just wanted to know if the process is standard county to county and so forth. I know the voir dire itself would be probably standard, but size of jury pool in this process and all of that, can you tell me what you know about that?
Well, they definitely vary from county to county, the size. So, and I think the courts are encouraged to get as many as possible, especially now because you have so many people that can't show up for one reason or another. Size varies considerably from county to county, but the process is always the same. Printed a questionnaire in a binder, access to the attorneys to be able to look at them, but not provided electronically. That's universal.
But the list is not. I guess what I'm asking, you have a smaller population area versus a larger one. The list is rotating. Is that right? I know a lot of jurors like to serve. Well, I don't know about a lot, but I know some people enjoy the process and want to get back on again. I'm just asking about this process with regard to, do they change month to month? How does that work?
So sometimes they'll draw from this. We might have a carryover, maybe used from one month to the next month. Typically speaking, almost always the case, it changes. So you have a trial term. We're going to try cases in February in Kennebec County. We're going to have a fresh jury pool for that month. That may be carried over to the following month, and so we may get some, that kind of carry over to the next list. Not typically, and I don't think that really happens. As far as people wanting to serve again, they're actually not allowed to. It's supposed to be a random process. We had that issue come up in Kennebec County a couple of years ago where people said they want to get their name back in, and we looked out in the jury pool, said, that guy was on my jury last month. And we recognized him and realized what had happened. It's not supposed to be that way. It is truly supposed to be random, as much as some people like to do it, and it's great that they do that.
So the list that you're given by the court is that current list?
Oh, yeah.
Thank you.
Representative Thorne.
Thank you, Madam Chair. I don't want to get lost in the world of hypotheses, but is a potential juror allowed to opt out of that questionnaire? And if not, what's the recourse? If they do
So-
decide not to fill
That
it up.
sounds like, yeah, that might be a question for Amy Quinlan. Amy, do you know if a potential juror is able to opt out of completing the questionnaire?
So in that case, the juror would not come into the pool. We need them to answer the question. So the folks who are not wanting to answer the questionnaire would not be part of that jury pool.
But there's no penalty for not answering the
No.
question.
No.
Right, and often they don't. I mean, questionnaires are not, they don't fill out all the questions for one reason or another. They still make it into the pool. Sometimes we'll follow up and say, well, you didn't put your occupation in. But by and large, people don't always fill out all of the form, but it's kind of a close enough situation, we get them in.
And that's true. I apologize. I thought you meant if they didn't want to answer the questionnaire at all.
Both. Thank you.
Yeah. Thank you. And I think that Justice Alexander has joined us. Although I'm not seeing him. Justice Alexander, if you are, oh, there you are. Thank you.
Hello.
Welcome to the Judiciary Committee. I think we probably have a couple of questions for you, but I'm wondering if first you can speak to us about the circumstances under which the court would exercise its discretion as to the juror questionnaires.
Thank you, Madam Chair, and members of the committee. Good afternoon. I was really here for the next work session, but I thought I could offer some insights on this one too. First of all, there's two types of documents you're talking about. There's the juror qualification forms. Those are the things that are sent out and have traditionally been sent out for all the time I've been associated with the courts, that then the jurors send back. Talk about their home address, their occupations, relation to law enforcement and stuff like that. Separately, there's juror questionnaires that ask often questions about the specific case that they might be selected on or specific issues. For example, if there's going to be a criminal jury term, they might be asked about a lot of issues regarding the criminal case. Both of those questionnaires are sometimes sent out in advance. Sometimes the particular case questionnaires are done the day of jury selection, as Walt McKee mentioned. And that's the way it is. There's an increasing practice of sending out longer questionnaires which I've discussed in the most recent jury instruction manual, longer questionnaires about case-specific or issue-specific questions to the jurors in advance, which are then reviewed by the attorneys. With regard to qualification questionnaires, which is really, I sense what you're talking about, the concerns about sensitive information about residential address, perhaps certain identifying information, perhaps personal information about prior issues the person may have had, domestic abuse, things like that, the 19 questions. In my experience, those have been made available to jurors, to attorneys and pro se's at the courthouse. And as has been pointed out, when they're available to pro se's, they're provided under some supervision, so they can't be phone copying of them or things like that with regard to it. I'm not familiar in my time on the courts or recently since, because I still follow it a lot because of my obligations writing the jury instruction manual, of a situation where a litigant, either an attorney who was representing someone or a pro se party, has been denied access to a questionnaire. The access might be supervised, but I'm not familiar with any situation where it's been denied. Making it available electronically is a different process because it's then sent out into the ether, if you will, of electronics, and that's a bigger concern. But anyways, that answers your question and the Madam Chair, and also the issues that I wanted to bring up about the qualifications, because there are two different things. The qualification form, which goes out and comes back with regard to every juror brought in on the questionnaire, which sometimes is sent in advance, sometimes is just done related that day and relates to the issues before the court or it may relate to the specific case. And there's an increasing practice of having questionnaires about the specific case sent in advance and then reviewed in advance before the jurors are brought in, to basically save bringing in a lot of jurors, reviewed in advance by both the court and the attorneys for the parties to the case. But I'm not, go ahead.
This, I just wanted to clarify that, and I'm glad you brought up the different terminology. This bill relates only to the juror qualification questionnaires,
yes.
the 19 questionnaires explicitly,
Yep. And as I say, I'm not familiar with situations where that's been denied at the courthouse. I can share the concern some have, Representative Reckett, for example, about the prospect if those questionnaires were sent out electronically in a situation where court supervision wasn't available. But they are always available, in my experience, always available to the attorneys for the parties and any pro se party who's a plaintiff or a defendant in a case at the courthouse.
Justice Alexander, can I ask you a question sort of related to the concern that Representative Reckett brought? So if I was a prospective juror and I filled out a questionnaire, but when I returned it, I indicated that, say, I had been a victim of stalking and I had changed my name and gone to great lengths to conceal my address and phone number and whatnot. What happens to people who, are ready, willing, and able to serve on a jury, but have concerns about that information even appearing on the questionnaire?
Well, if they bring that to the attention of the court, and it'd be the clerk in advance, they likely would be excused from responding, because I don't think we could have, and as Walt McKee pointed out, an incomplete answer to the questionnaire would mean the attorneys wouldn't want to consider them anyways. I have had unfortunate situations. I can recall a specific live situation, just the type of example you're having, where a juror, the issue was, were you a victim of sex abuse? Does not appear on the questionnaire. The juror suddenly was about to be picked or available as the pool for consideration for a sex offender questionnaire, and demonstrated, it was obvious to me in the courtroom, considerable emotional difficulty. At that point, I took a recess and had a court officer discuss the issue with the person and excuse the person who had been a prior victim of sexual violence. And, but that type of issue, if the juror doesn't want it and has a good reason for not wanting it to be displayed, probably would mean the person would be excused from jury service. Because one of the things we have to ask, if a case involves sexual violence, domestic violence, is, have you have any experience with this as a witness or as a victim or someone who's been charged in a case? Hope that answers the question.
That does. Thank you very much. And I think it's prompted another question from Representative Reckett. Go ahead, Representative. We're not able to hear you. Yeah.
I'm appreciative of your answer, Justice Alexander, but it brings up for me what is a lingering problem I have with the jury system, which is that we screen so many people out that we end up with a lot of people who don't know anything about much of anything are in the juries, and everybody who has any expertise at all about almost anything gets excluded, and it's just frustrating for me to watch. I know that's not the question in front of us right now, but the whole issue of what gets disclosed and who gets dismissed is a worrisome one for me. I don't know the solution to it, and it's certainly not in this bill, but it's just a frustration. And I don't think it's just that I got excluded, which I did, but I can understand that, but it's just really, it's hard for me because it feels like we eliminate everybody who might know something about life in general. I don't know. It's just hard for me to conceptualize.
Yeah, that I must say, and perhaps Walt McKee could jump in on this too. I must say, Representative Reckett, that's not my experience. Yes, people who have had a specific experience related to the issues that are going to be litigated, be it being involved in a automobile accident with an injury where the issue before the court is seeking recovery for that, having been a victim of sexual abuse, that's the case. But in my own experience, I think we have a lot of very competent, committed, interested people who have a wide range of life experiences, who are available to sit on the juries once we get through the questionnaire process. And as I say, I write about this. I also did jury trials because while I was on the law court, I was glad to go out and help out, and I did a lot right up through basically November of 2019 before I retired. And my total experience is that generally we did not have only people that were sort of outliers in terms of information or education or a background on society. We have small business people, we have teachers, we have people who have professional responsibilities in communities. We have people who are blue collar workers. We have people, hard workers, work in healthcare and things like that. A full range of people, which I think is relatively typical of the main population participating in juries. We have some challenges. For example, we just don't have enough people of color, for example, to provide a jury that
Madam Chair, I just want to raise a point of order that we need to stay focused on the bill at hand, even though these issues are of concern. We're kind of going off topic.
I apologize for my part in that. And I'm comforted by the Justice Alexander's remarks. But I will back totally off at this point on that.
Thank you very much, Representative Reckett. And let's move on to a question from Representative Libby.
Thank you, Madam Chair. I'm not convinced that we are going to bring up any new information at this point. I would perhaps like to see us move as a committee toward discussion of where we'd like to move with this and move towards a vote.
Thank you for that suggestion. I did have one more question for Justice Alexander. Are you aware of any list of factors that are taken into account in determining whether the jury qualification questionnaires are not shared with attorneys or pro se litigants?
I am not, but as I said, because in my experience, I do not recall any situation where the juror qualification questionnaires were not available to be shared with people. Sometimes I can recall pro se litigants didn't bother looking at them. The attorneys, because they have an obligation for quality representation, always did look at them. So I can't say any factors because I'm just not aware of where that happened.
Thank you. And then just Amy Quinlan, one final question for you. I know that we talked about this earlier, but do you have any information about circumstances in which the juror qualification questionnaires were not shared with an attorney or a pro se?
Senator, I do not. I don't think that is a frequent occurrence. If it happens very rarely. So as I said in the beginning, I don't believe that there's a checklist just because, as Justice Alexander had said, it just doesn't happen very often, if at all.
Okay, thank you very much. At this point, we're going to focus on committee discussion of the bill. And so with much appreciation to all three of you, thank you so much for participating in the conversation today. And I'm going to move you back to the attendee portion
Thank
of
you.
the meeting. And Representative Evangelos, did you have a question for one of the three people who I've just excused from the meeting?
No, committee discussion.
Okay, go ahead. Thank you.
Well, last week, Madam Chair, we heard from Justice Stanfill that the criminal side of the docket is 51,000 cases. And, you know, we have these chances to make these small improvements just to help expedite the crisis we're in. So I'm going to support this. I'll wait to make a motion to see how others feel.
Thank you very much. Would other committee members like to share their thoughts on the bill? Go ahead, Representative Senator Keim.
Well, the only thing I would be interested in with this bill, just given the judicial branch's testimony, is to change the word to must, but given the testimony we've just heard, it doesn't seem like that would actually impact what's happening. And so I would be willing to, which made me comfortable, of course, because I want people to have access, but it seems they are getting proper access at this time. And the greater intention of the bill was for the electronic access, which doesn't seem we can do. So I would be satisfied with an ought not to pass after what we've heard today.
Senator Sanborn?
I'm just a little skeptical of the idea that it's not possible to provide the electronic information. I mean, I don't know, I guess we owe some deference to Ms. Quinlan and to the judicial branch. But I think we also, as a separate and independent branch of government, have to push back a little bit on the idea that password protected PDFs couldn't simply be generated and sent to attorneys on a pretty routine basis without a lot of, certainly without a multi-million-dollar investment. So I'm weighing the issue of sort of my slight skepticism that in 2022 there's simply quote unquote no way to accomplish this versus it would be a change in procedure and it would require people to do their jobs a little bit differently. I think the question or the concern that I have is we did hear from Justice Alexander and Mr. McKee that pro se litigants are generally supervised or that they are receiving the information with a little bit of supervision, maybe not in a room by themselves so they can't take cell phone pictures. That's the piece I don't believe this bill has addressed at this point. Because there's no distinction in the bill as between attorneys and pro se litigants in terms of whether they would simply receive an electronic encrypted password protected file. So that's the only piece of it that I don't believe we've addressed. And so that piece of it does give me a little bit of pause because folks on both sides, both the sort of judicial side and the defense bar, brought up that current practice.
Yeah, that concerns me as well. Well, actually, the concern that I have is even if something is in a protected document, this information, some of it anyway, is very private. And I'm just concerned if we have the custodian of the information raising concerns about the ability to continue to maintain that privacy, that we should be paying attention to that. I understand exactly why having reviewed confidential juror or juror qualification questionnaires in connection with my work as an attorney, that it would be extraordinarily convenient to have them sent directly to the attorney's office in a password protected document. But I'm concerned about the fact that the initial custodians of that information don't feel that process would be secure enough. So I guess I haven't made up my mind on how I feel about this matter yet. Representative Babbage.
Thank you, Madam Chair. Yes, I did not hear any justifications for court discretion regarding the release of the qualification forms. As I look at the qualification forms, I do not see the type of private information that concerned me, although a mere address could be a concern to somebody that should be disqualified for domestic violence issue, privacy issues, and that kind of thing. But the form itself, so the must part of it for me is now acceptable. I do want to say that years ago, the digitalization, I guess, of the judiciary was sold to the legislature for its efficiency, and I do understand that through implementation, problems and cost, and the cost has been very significant, do arise. But I too am thinking that if we put this into effect and it becomes effective as of the summer of 2022, that something could not be worked out there. If I have any questions right now, it would be regarding pro se litigants, but I'm not sure where I am on that, so I'll listen to the rest of the committee. Thank you, Madam Chair.
Committee members, I'd like to reach out once again to Amy Quinlan. She's still in the attendee portion of the meeting, and get some more details on the module that she described that could be used for this process. And so with your indulgence, I'm just going to bring her back onto the panel to ask that question. Welcome back, and sorry to keep sending you to and fro in cyberspace. Could you please provide us with some more information about the module that could confidentially transmit this information, what it would cost, how long it would take to install it, and any other information that you might have about it?
I certainly can, Senator. Thank you for asking the question. So as you may know, we've engaged Tyler and their Odyssey suite of products for the e-filing and case management system, and we are in the process of implementing that. And the goal ultimately is to transmit as much information as possible electronically within the safety net of these systems. We did specifically look into the juror module that Tyler provides and got quoted a cost of $675,000 for a 5-year period for that system. We did initially have conversations about implementation time, but that I would have to go back and get dates. I don't want to. That would have been last year. And so I just would want to make sure, and I'm happy to do so, get an estimate on time to implement that. But the one additional piece to that is, with regard to the rollout of this system, and while this is a very important piece of it, there are lots of pieces of information like this. Besides, the juror questionnaires, our ultimate goal is to be able to electronically transmit that information, as I've said. So the idea of doing this a bit piecemeal gives us some pause, but we did want to look into that information and have those numbers for you. And I will find out the time frame for you as well.
Okay. And then another question on the suggestion that these questionnaires could be scanned into a password protected PDF document. Is that something that the judicial branch IT folks have looked at from both a feasibility perspective and from an information security perspective?
So I know that they looked at that. I cannot, and why they ended up looking at the Odyssey module, because it's more complicated. And I understand that, Mr. McKee was talking about it in terms of his experience at his law firm. It's a different thing within the judicial branch. There's more complications to that for us. Time frame. It's not just sending one email through password protected processes. So I can get more information on that as well. We did look at it. It's why we turned to the module, because this seemed to be more efficient, although certainly not inexpensive.
Okay, thank you. Thank you very much. I see two hands up. Are those questions for Amy Quinlan, or are they? Okay, so Representative Reckitt, go ahead with your question, and then we'll continue with committee discussion.
Thank you. I just wanted a piece of information. How many jury trials are there a year in Maine?
So
in a usual year, not the last couple, where it's been crazy.
So I would have to get that information for you too. And I apologize. I've been so focused on the pandemic numbers that I haven't gone back to look at typical juror numbers for a while, but I can get that to you as well. And that's really the concern. I mean, right now during the pandemic, there are fewer to deal with, but that won't hopefully be for long. So it becomes an issue of scale as well.
Madam Chair, I could answer that question.
I'm sorry, who's speaking?
Justice Alexander.
Oh, thank you. Okay, go ahead.
Yeah, we did a study between May of 2018 and May of 2019, which is before the pandemic hit, because we were concerned about the adequacy of some reporting of how many jury trials there were. And we did a fairly thorough study. And for that year, there were a total of 210, totaling both criminal and civil. Well, that's a big drop from maybe 20 years before then, when we were dealing with, maybe 500, and 30 years back and around the end of the 80s and early 90s when we're dealing with 800.
Thank you. Thank you. That's very helpful. Okay, we're going to now return to committee discussion. So I'm going to send both of our guests back. And committee members, I would like to suggest, I'm not making a motion, but I actually would like us to table this matter until we get additional information about both the cost of the module, and the timeline for implementing it, because I do think that if that is the most secure way to provide this information and the most efficient way for the judicial branch to do it, then I think we need to take that into account in whatever decision we make on this legislation. And so I put that out there for reactions from the committee and a potential motion from one of my colleagues. Representative Moriarty.
Madam Chair, if we table, would it be appropriate to request information from a source who has not yet appeared before the committee?
We could certainly do that, because we would take this up at another work session.
As long as Justice Alexander is with us, as you know, he also serves as a member of the Maine Commission on Indigent Legal Services. I don't recall that they participated at the hearing last year. I have nothing from them. I'd be curious to know what their position is, because I've listened in or observed a number of their meetings from the time we adjourned last summer until currently. And there's been a lot of discussion of the sheer quantity of time it takes, particularly in the rural areas, to travel to a courthouse, to say nothing of the time required to sit around the courthouse in line and observe the notebooks or the paper documents, all of which makes it very difficult for these people to perform their services for what they're paid. So I'd be interested in knowing their position.
Thank you. That's a great suggestion. Committee members, any reaction to my suggestion that we table this to get the additional information about the timeline for implementation? Representative Evangelos?
Sounds like a good idea, Madam Chair. People need to get their questions resolved, and then we can make an informed decision. I'll move to table.
Thank you for the motion to table by Representative Evangelos. Is there a second?
Second.
Seconded by Senator Sanborn. And this is a non-debatable motion, and so we'll move on to a roll call vote on the motion to table. And again, to clarify, this is a motion to table LD 233 while we gather some more information. And Supi, we're ready whenever you are.
I'm happy. Thank you very much, Madam Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Kine, Senator Kine.
Yes.
Senator Kine votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Representative Newell. Representative Newell is absent. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent.
Thank you very much. And so the motion to table carries, and we will take LD 233 up after we obtain the additional information. So the work session on LD 233 is now closed. I would like to give committee members a brief break before we take up our final bill today, because it will be, I think, a lengthy discussion about the amendment to the foreign judgment statute. And so if we can all return in 5 minutes at 2:21, that would be really appreciated. Thank you, everyone.
Unless you're off mute.
Hi, everybody. If you're back at your desks, I think we're getting ready to start our work session on LD 903. Thank you, everyone. And we're back, and so I will open up the work session on LD 903, the Uniform Foreign Country Money Judgments Recognition Act. It is a mouthful. And Peggy has been working very hard with the Uniform Law Commissioners on this legislation. And Peggy, did you want us to turn it over to them, or how would you like to proceed?
Thanks. Actually, Caitlin Wolf, who is an attorney with the Uniform Law Commission, can walk you through this amendment. I mean, she understands it better than I do, I think. But I will tell you that the parts that are in red were our recommendations from the judicial branch, and Laura Perlman is here from the judicial branch, and she's the one who made those recommendations on behalf of the judicial branch. Maybe if I can step you back a little bit, you had two concept drafts last year, 902 and 903. 902 is this bill, the Uniform Foreign Country Money Judgments Recognition Act. 902 was the Uniform Registration of Canadian Money Judgments Act. Those two acts actually need to, well, at least the Canadian one needs to reference what goes on in the Foreign Country Judgments Act. So it made sense to deal with them in one bill because you can't reference something in another bill. So plus they were both concept drafts. So you said, we don't need 902, we'll use 903 of the vehicle. You carried it over. I used the information from Caitlin and Justice Alexander, and Paul Chaikin was also a little bit involved in it. And Representative Moriarty had sponsored it. And I put together an amendment that has both of these bills in it. And it's they're sequential chapters. I haven't merged them, but they're sequential chapters. And you'll see that the proposed chapter 761 goes back and cross-references some of the language that's in, or the process that's in the new chapter 759. And this takes, we have a Foreign Money Judgment Recognition Act now. This will take the place of it. So I sent the draft of this amendment to the judicial branch, and I also sent it to Caitlin and Justice Alexander, and they responded with some changes that I was able to incorporate, but the judicial branch has just responded a little more recently, and so that's why theirs are in red.
Thank you. And so we, committee members, we have the document available electronically, and I'm assuming that we do not need to screen share at this point. But as we're going through our conversation, if committee members feel like it would be valuable to screen share, then we can definitely do that. So just raise your hand and ask.
And if I could add one more thing. Yeah. Justice Alexander sent in about 4 pages of testimony about, not testimony, but kind of a discussion of what this bill does, and maybe some suggested changes that you might like to consider. And I think he's prepared to respond to your questions, or go ahead and talk about those suggestions.
Okay, so thank you. Let's start with Caitlin Wolf presenting the amendment, and then we'll hear from Laura Perlman, and then we'll hear from Justice Alexander. And again, committee members, if you feel the need to screen share, just let us know. And with that, Caitlin Wolf, the floor is yours.
Thank you so much, Chair Carney. I really appreciate it. Members of the committee, it's a pleasure to be with you today to discuss the proposed amendment. So as Peggy laid it out, what you have before you is a fusion, if you will, a combination of two different uniform acts. As Peggy said, it really, in contemplating adopting these acts, it only makes sense, and in fact, for the second piece of this, that Canadian Registration Act, that is really, can be best viewed as a supplement to the Recognition Act, which is the first uniform act you see in the bill. So it's a supplement to that process. It refers back to it, as Peggy mentioned. So just to dive right in and set the table a little bit, we nickname it the Recognition Act because these have such long names. So the Recognition Act piece would be this proposed chapter 759 that you have in front of you. And in essence, what it does is it provides rules and procedures for recognizing and enforcing money judgments that come out of foreign countries. So Maine's existing law on the subject is actually the previous version of this Uniform Act, which was finalized back in 1962. Maine adopted it in 1999, and it's been virtually, untouched since that time. So what you have here at the very beginning in the Foreign Country Money Judgments Recognition Act, it is not a whole-scale, change up of your current law. What it does is it refreshes some of the definitions. So again, the definition of foreign country and foreign country judgment. You have some different terms in current law that were causing confusion and litigation across the states that had adopted this. So we've refreshed those and clarified those. And then sort of moving through the bill, you'll see here the applicability section as well as some exclusions. That's virtually the same as your current law. We do go in here and clarify that this is not a statute to be used to enforce domestic relations judgments from other countries. Other law takes care of that. So we have some clarifying language there. And then Section 8804 really gets into sort of the meat of the act, which sets out the standards for recognition. So that can be viewed as sort of step one in the process. Does a foreign country money judgment meet the standards that are set out in this act? What we're talking about there is the foreign country judgment has to be rendered in a foreign country that has an impartial judicial system. There must be subject matter jurisdiction and personal jurisdiction over the defendant in that foreign court. So that's what the Maine court would be contemplating and would be reviewing for this part of the proceeding. Sort of moving forward in the bill, there are also some sort of discretionary grounds, discretionary factors that the Maine court can consider whether or not that recognition would be possible or not in Maine. So those discretionary factors are then set out. One of the new changes in this bill, one of the new updates to your current law is we're setting out for the first time very clearly which party has the burden of proof for these sorts of actions. So we say here the party resisting recognition has the burden of proving that one of these grounds is in fact the case. We have some details more about personal jurisdiction, what exactly that means in the context of one of these foreign country money judgments actions. And then what's really the new language here is current law in Maine, and the current or the previous version of the Uniform Act doesn't specifically say what the procedure is for seeking recognition and enforcement. So in Section 8806, we just say in the black letter text that you need to file a lawsuit to seek recognition and enforcement of a foreign country money judgment. That wasn't specified in previous law. So we just say it here in the black letter. We say you can either file an original action if you're already in a lawsuit. You can bring this up as a counterclaim, cross-claim, or as an affirmative defense in that already existing suit. So that's brand new language to clarify. And then in essence, if step one, if those recognition, if the recognition was met, if that was handled, then in essence, the result would be that the judgment could be enforced just as if it were a judgment rendered in Maine in the first place, or if it was a sister state judgment. So step one is recognition. Step two is enforcement. Another important thing to note is, of course, it needs to be a final a judgment rendered in the foreign country. It can't be out on appeal. So, of course, we have some language in here staying the proceedings in Maine if, in fact, that foreign judgment was up on appeal in the foreign country. And then just flipping through here, one of the other important new pieces that this would add to your current law is a very clear statute of limitations. That's also missing from current law. It wasn't in the previous version of the Uniform Act. So we add here a 15-year statute of limitations just to make that clear. I think I'll pause there for now. That's sort of step or stage one. That's the first Uniform Act that's included in the amendment. But in short, it's just a refresh and update to your current law on this subject to handle some issues that came up in litigation over the past several decades across the country, refreshes definitions, and just tries to add clarity to a statute that's been on the books for some time now. So Chair Carney, I don't know if you want me to pause for questions at this point. Okay, do that.
Thank you. And I'll start out with one question. So you had gone through and given us a great overview, and you highlighted the sections that would actually be a substantive change in Maine law. And I just want to make sure that we all have that down. Going backwards, the addition of the statute of limitations is new. And then the creation of a procedure for filing an action in according to the Maine Rules of Civil Procedure to gain recognition. And then you talked a little bit about the non-recognition grounds, but I wasn't clear if that was a substantive change in the law or something that was updated.
Yes, Chair, to respond to that. So there are most of the grounds you see there, those discretionary grounds, are in existence in Maine law. The final two that you see in that section, so subsections G and H, those are new. And that is, again, to clarify some questions that have come up in litigation over the course of the past few years. So those are new. The rest of it is a reflection of your current law.
Thank you. That's really helpful. Committee members, are there any questions about that portion? So that would be essentially section 2 of the bill on pages 1 through 5. Any questions about that? Okay, I'm not seeing any. Thank you. Caitlin, if you want to then continue with section 3 of the bill, we'd appreciate that.
Absolutely. Thank you, Chair Carney. So to move forward with section 3, and this is why Peggy was mishmashing everything together. So the next section of the bill would adopt the Uniform Registration of Canadian Money Judgments Act in Maine. This is a newer act of the Uniform Law Commission. It was finalized back in 2019. And the whole purpose behind this is it builds upon the act that we just discussed, the Recognition Act. It takes into consideration sort of the special relationship that the United States and Canada has. Canada is one of our top trading partners. As a result of that commercial activity between the two nations, unfortunately, litigation does result. And the thought behind this act was to try to harmonize a bit of the law between the United States and Canada and to offer a streamlined registration process as an alternative to filing a lawsuit, which is what's required under the Uniform Act that we just discussed. Instead, this would set up a separate registration procedure. So rather than filing a lawsuit to get your Canadian money judgment recognized and enforced in Maine, in essence, it would just set up an administrative process. So the Canadian judgment could be recognized if the individual seeking recognition for that judgment filed a registration with the clerk of court in Maine, the appropriate clerk of court where you could, file a lawsuit if you wanted to pursue the other procedure. And in essence, files the paperwork, pays any necessary registration fee, and of course, produces notice, provides notice to the person against whom registration is sought. There's a 30-day period then for the person against whom registration is sought to, say, hey, either one of those, standards for non-recognition wasn't met, or perhaps that registration paperwork was incorrect. In essence, they could say, hey, wait, something's wrong with this. But after that 30-day period, then enforcement could be sought for that Canadian judgment in Maine. So the benefit here, of course, is we're conserving judicial resources. There's no need to have the full-scale judicial proceeding, filing a lawsuit, conserving legal costs and time for the parties as well. And again, just trying to think of a way to streamline and make more efficient the process for these particular Canadian judgments between the two nations. So that is the thought behind this act. And again, it does refer back to the Recognition Act we just talked about a little bit. And one other thing to flag is, under this Canadian money judgment registration process, there is by no means a requirement to use the registration process for a Canadian judgment. A person could still choose to pursue the other method we just discussed, filing a lawsuit and using that procedure. You can't pursue both options at once. So you either have to choose registration or choose the lawsuit route. But I just wanted to flag that as well. But it really just supplements and adds on to the Recognition Act that we just discussed. And I would be happy to take any questions on this act.
Thank you. It looks like we do have a question. Go ahead, Representative Moriarty.
Thank you, Madam Chair. Ms. Wolf, this is obviously a state act. I don't know whether there is a national statute on this subject, but I guess my real question is, do we have to square our process with the various Canadian provinces to make sure that there are no misunderstandings or glitches along the way? How does that happen?
Yeah, Representative, that's a great question. And actually, and I'm glad you asked it. So there really is no need to square this process with the various Canadian provinces at this time. And in fact, I should have flagged this for the committee, but the ULC actually drafted this act with our Canadian counterpart just to make sure that things were harmonized to the extent possible. So there's a Uniform Law Conference of Canada that does very similar work to what we do. They have an act on this subject, and to the extent we could, we tried to harmonize them. So I'm glad you posed the question, Representative, but at this point, there really is no need to do any additional sort of drafting between the two. So thank you for that.
Thank you.
Other questions, committee members? I have a question for you. How many states have adopted the uniform or have enacted the uniform registration of Canadian money judgment acts?
Yeah, so the Canadian piece, the Registration Act, has been available the last just 2 sessions, and 4 states have adopted it so far. So Colorado, Nebraska, Nevada, and Rhode Island. And actually, Nebraska and Rhode Island followed the approach that's here in this committee amendment. They actually did both of these uniform acts at the same time, similarly to how Peggy prepared the bill amendment here. So, and then 29 states in total have adopted the Recognition Act that we talked about a little bit earlier.
Thank you. Committee members, other questions? I am not seeing any. I think at this point, Caitlin Wolf, if you can stay on the panel with us, and we will bring over Laura Perlman from the Maine Judicial Branch, because they have gone through and suggested some additional edits. And so I think we'll just go ahead and review those in the sequence in which they are appear on the document.
And can I just add that I flagged in yellow the very specific questions I had for the judicial branch. So that's why it's highlighted in yellow, because this was still kind of a working document. So I was looking for some kind of answers from the judicial branch, and I believe Ms. Perlman has been able to provide those.
Great. Thanks, Peggy. Laura Perlman, welcome to the Judiciary Committee.
Thank you, Senator Carney, and thank you, members of the committee. It's a pleasure to be here. My name is Laura Perlman. I'm the manager of civil process and the foreclosure diversion program at the judicial branch. And I was asked to go through and address any areas that Peggy highlighted. So that's what I've done. And I am happy to walk you through those if you wish. Is that what I'm here to do?
Yes, that would be really helpful to us. If you can just take start from the first suggested change and let us know, just key us into the page that you're looking at. And
first one is on, yeah, so I'm sorry, I didn't mean to interrupt you.
That's okay.
First one is on page 4, section 8806, which is about the procedure for recognition of a foreign country judgment. And we suggested taking out filing an action and making it commencing an action, because it's cross-referenced with the Canadian Registration Act, which requires service of the notice of registration. So rather than have any confusion between filing and service, it was clearer to us to say commencing an action, which involves both things here and in compliance with the Maine civil rules. That way, when we get to the Canadian Act, it's service in compliance with the Maine civil rules. And then in section 2 of that same section 8806, subsection 2, that's a similar suggested change. Filed and served, from if we have a counterclaim or a cross claim that needs to be filed, it would also need to be served.
Thank you.
Sure. And the next suggested change was we were asked to recommend an effective date. We recommended January 1 of 2023 to give us time to dig into forms and processes and make sure we can launch it well.
And that's on page 5.
I'm sorry, yes, page 5.
Yeah, great, thank you.
If we move on to page 6, we're moved into the Canadian Registration Act. Yeah. Yes, not the Recognition Act is foreign country and Registration Act is Canadian. So the 8904 is where it speaks about a copy has to be authenticated of the judgment, authenticated copy of the judgment. And when I looked back at the cross-reference to section 8806 back on the earlier page, there's no mention of authentication. So there's no reference to an authentication or what would be necessary for a judgment to be authenticated under that section. So neither act really digs into this to define authenticate or set a standard. So it made sense to me to just remove that cross-reference and allow the court to determine what it would require in terms of authentication. But
let me just pause there and ask Caitlin. Caitlin, do you know if there is any portion that refers to or requires authentication in the Recognition Act?
Chair, I don't believe we have any language particularly about authentication in the Recognition Act. We don't establish that with, definitively.
Great, thank you.
Then let's see, the next change is on page 7. And this has, well, we were asked to comment on how the fee would be set, and I've just suggested language to say the fee would be as set by court rule or order. Currently, there's an administrative order that addresses fees, and it just seemed sensible in a statute to make it a general language there. On section 3 on the same page, right below that letter K, on receipt of registration, this language change was simply to clarify that clerks don't file things, but they can accept the registration for filing. And in the court system, we have docket numbers, but they don't call them registration docket numbers. So, and then the judgment would be entered in the file. So that was just a terminology change. Number 4, I tracked the proposed form, and from my reading, it seemed to simply straight up track the statutory requirements. And it seemed unusual to have a statute include a form for the court to use. So, or maybe this was intended for individuals to use the form, but generally our court would create a form based on statutory requirements. So we recommend to take the section out so that, because we would take the statute and create a form based on it. That's simply the recommendation.
Okay.
You decide otherwise, then we could go back and do some of the separate choices that are in here depending on the court, but that was our recommendation.
Thank you. Let me just turn for a moment to Caitlin Wolf, and because I was curious about this too when I saw the form, which is not typical in Maine statutory language. Have other states opted out of the form? I know that not many have adopted the legislation yet, but
Yeah, I'm happy to get a definitive answer to you. Off the top of my head, they have adopted it, but I'm happy to come back to the committee with the definitive answer on what those other 4 states have done. And yes, it is a little bit unusual to have a sample form sort of there within the black letter text. And I will just say, if I may, that if indeed you do decide to take out this form and to defer to the court's rulemaking process on this, that's just fine. It was really put in there intended to be sort of a safe harbor if folks, to use as a guide for the states. So yeah, and I'm happy to get back to you with a definitive answer on what the other states have done.
okay. I don't think an answer on what the other states have done. I was just curious since it's contrary to the practice of our state. But thank you for offering and for your answer. Representative Babich, did you have a question?
Yes, thank you, Madam Chair. Ms. Wolf, I just wanted to know, is there anything in the form that would not be included in narrative that would be omitted possibly that you think there is of importance should it be left to the courts?
I think the main thing in the forms are, we do require that the parties do that calculation of the money judgment, to do the calculation of between Canadian dollars and US dollars, things of that nature. Again, if the court wishes to just use this as a guide, that's fine. Again, it was just intended to be a safe harbor to ensure that the parties really have everything that they need.
Thank you.
Thank you. And Laura, are you suggesting that there be any reference in the statute to a court-provided form, or would you just be silent on that? Which is your recommendation?
That's interesting. I mean, we did note that the way the statute is written, it doesn't say this form has to be used. It says it would comply if this is used. So, I mean, it's clearly not mandatory. And I understood that it was to be helpful. And so I don't know. I can't really answer that question specifically because we were just simply recommending that we didn't think this was necessary, because we would take, I mean, in all likelihood, we would just look very closely at what this form does and use it as a helpful aid anyway, but just wondered why it was in the statute, that's all.
Okay, thank you.
Let me go on here. And then the next, on page 11, under section 8905, we were asked to specify between garnishment and trustee process, and the Maine court rules have a process for trustee process. So I made that selection. And then when we move down to the next page on 8906 is the notice of registration, and that is required to be served. And this relates back to section 8806 in the previous act, which I mentioned before. So we reference that needs to be served in the same manner that you would serve a summons and complaint under the rules of civil procedure. And I, because they didn't seem very different anymore, once we made that change, I suggested combining those two sections. It's just a small suggestion, and I don't have a strong, it's not a strong recommendation, but simply just to combine those two. And then again, under the notice contents, the docket number would not be a registration docket number, simply a docket number. And then page 13, it would be a motion to vacate as opposed to a petition to vacate. We were asked about clarifying that language. And it would be a judgment. So I took out the brackets. That's all on page 13. Then on page 14, section 8908. Again, it's a motion to vacate. There was a little typo. I think another January 1st, 2023 effective date. I think that covers everything. That was on page 15.
Thank you so much. Representative Babbitt, did you have another question? No, okay. Let me open it up then to questions for Laura Perlman. Committee members, any questions? I think you covered it very thoroughly. Thank you. I don't have any questions either. Let's see. So you've both given us a great explanation of the draft amendment. And I know that Justice Alexander also had some information that he wanted to provide to us. And so at this point, I will bring him over to the panel. Yeah, and here he is. Welcome back, Justice Alexander.
Thank you, Chair Carney, and hello again, committee members. I submitted testimony outlining some, suggestions I had. Most of them were suggestions for the committee to consider. I wasn't particularly advocating anything. Unless you want me to sort of go through that reading, I'm happy to rely on that and otherwise take questions from the committee. The one thing I would add is I absolutely agree with the recommendations that the judicial branch made with regard to amendments here. I agree with all of those, and I think it's particularly important that the statute not include a form, because the judiciary is, as you know, in the process of doing the electronic filing and electronic case management, and that involves altering a lot of forms, and you don't want them to have to come back to the legislature every time they need to alter a form. So you definitely don't want that form in there for what situation the judiciary is in now. Beyond that, I'd be happy to take questions, if any, unless you want me to discuss something that's in my testimony.
I did not feel, I didn't have any questions. Committee members, are there any questions for Justice Alexander? Go ahead, Representative Libby.
Thank you. I appreciate all of the technical explanations and have been reviewing our information from last session on this bill or the combination of bills. But what I would find particularly helpful as one of the non-lawyers in the group would be, how does this change benefit Maine people? This is a very this is a very different type of bill. It's not like a social issue or anything where your average Maine person is dealing with this. So I would very much appreciate kind of a picture from the layperson perspective on how this benefits us.
Well, I'll try to answer that some. I think it's a great benefit to Maine people, particularly those who, people, small businesses and all, particularly those along the border, which is particularly active, but interactions between persons, businesses, entities, particularly in Aroostook and Washington County, and I've experienced it a good bit in Washington County because I used to sit there a lot. And this makes it much easier and a generalized accepted statutory process to render a Canadian, register a Canadian judgment and make it available to be considered in the United States the same way as a judgment of the state of Maine or some other state would. And there are a lot of possible purposes for that. Looking at what someone's assets are, attempting to collect a judgment, determining whether this person has assets or not for all kinds of purposes. And I think it facilitates things in a much better way than the money judgments recognition process does, because, as has been pointed out, you don't have to actually file an action. You can simply register it in the court, a much simpler, much cheaper process, and then have that judgment available to be considered like anything else. And to say that would be particularly available where we have a lot of cross-border dealings with regard to Aroostook and Washington counties, to then say, okay, this is a Canadian, and we're only registering money judgments. I recognize that. This is the Canadian judgment. It's been rendered in favor of someone or against someone. And then here it is to consider for a lot of processes in which may be relevant in the United States.
A follow-up, if I may, Madam Chair.
Yeah, I was just asking you if you had a follow-up, but I was muted. Go ahead with your follow-up.
Thank you. I appreciate that explanation, but I wonder if you could go even further, and I'm sorry, again, this is a layperson here, not attorney. If you could go even further and give an example of how this could be used. I get that it's cross-border. What does that mean for a small business owner who is looking to have this applied, and how does it help them? I really need to understand that nitty-gritty before I can support it.
Okay, well, for a small business owner, if you are concerned about someone's ability to pay or not, you can then look and see if there's a judgment been rendered in favor of that person that shows that person has assets, or there's a judgment been rendered against them that shows they may have liabilities, which you may therefore question whether you want to extend credit to them, or maybe you want to have and again it's only money judgments, but still you may want to consider whether you even do business with the person if he's had 5 money judgments against him in Canada involving the same type of businesses that you do, or has that type of process. It has all types of things. Also, again, if you do have an action against the person in the United States, and this would apply for the Recognition Act too, you could then have this judgment, if there was one in his favor, to show assets that you might recover on. I don't know, again, yeah.
That is helpful. Thank you.
Yeah.
Other questions, committee members? Justice Alexander, I actually wanted to ask you a question about your first suggestion regarding the registration of Canadian money judgments. You pointed out that the Foreign Country Act applies to judgments that grant or deny recovery of money, but that the Canadian Act only applies to granting recovery. Could you speak to why it might be important to add the reference to denial of recovery to the Canadian Act as it is found in the Foreign Country Act?
Actually, it's more narrow than that, Senator Carney, because the first paragraph of the Canadian Registration Act, Canadian Money Judgments Registration Act, says that it can apply because it cross-references the Recognition Act's terms to a grant or deny of judgment. The only time where it then is limited to a grant of judgment is a more complex judgment that both awards money and also gives other relief which can't be subject to either the Recognition Act or the Registration Act. And so when you have a judgment that's of several counts, one of which is a money judgment, and then one or two or three of which involve something else, at that point only, it's limited to matters which grant a money judgment. And I didn't see the necessity of that. I provided an example of where you may want to have use a denied money judgment or a minor money judgment to use that in the United States for certain purposes. The example I gave was but that's what's important. So it only applies to multifaceted judgments, of which a money judgment is only one issue. That the limitation to grants only applies to those multifaceted judgments. Doesn't apply to a straight money judgment, which is the first paragraph of the section.
Okay, but I understood that you were suggesting that we include the ordinary.
Yes, I am. I would amend the second paragraph to either just cross-reference the Recognition Act the way the first paragraph does, or specifically say grants or denies in the second paragraph.
I'm losing you when you're talking about first versus second paragraph.
Okay.
Sorry, because
okay.
I read your example and I see that it does seem to make a lot of sense, but is it 8903 that you're talking about?
Okay, at 89031 it's okay. 89032 is the only area where there's a problem. And there I'm simply suggesting at the end of the first paragraph in number 1 that 89032 be amended to say to the extent of the grant, I would add or denial of recovery of a sum of money.
Okay, thank you. Committee members, any additional questions for Justice Alexander? All right, I am not seeing any other questions. Let's see. Wanted to ask Caitlin Wolf and Laura Perlman both about the addition to grant or denial on page 5 in section 8903 subparagraph 2. Do you have any concerns about that, including the word or denial, negatively impacting the effectiveness or implementation of the statute, or maybe being beneficial in helping to carry out the underlying policies of the statute?
I just have one question.
Go first. Yeah, go ahead.
I just have a question on that paragraph. I think grant also appears higher up. Would Justice Alexander also recommend adding or denial in the first instance when grant appears?
That's okay. That would be okay with me. The key place I wanted it, because it relates to the extension of the amendment, was in the second paragraph. It'd be okay. Well, in the first part of it.
I'm sorry, are you saying that it would be okay to include in the first sentence of subparagraph 2 that grants
or denies,
or denies, and then we would get rid of the word both and have it continue to read recovery of a sum of money?
I think so. I may not have that. Yeah, but
I think the both refers to the judgment. This is a multifaceted judgment.
Right.
So it's either something about the money and then also other relief.
Right.
So I
Okay.
think that's what the both refers to.
Yeah. So you need to keep both.
I understood. Thank you. Caitlin, did you want to weigh in on that as well?
Yeah, I think Justice Alexander, it might be helpful for me if you could really briefly explain, what problem you are trying to solve with the proposed language change. I'm just trying to understand how the addition of the word denial would assist when the ultimate purpose of the act is for enforcement of the judgment, essentially to collect a money judgment. So if you could talk through really briefly why adding the denial would be helpful, that might help me come to a conclusion about this.
Okay, well, I appreciate what you say about the purpose of the act is to only to sort of facilitate collection of a judgment. That's not that term does not appear to me in the act. It appears to simply authorize registration of money judgments. And in the 89031, it then cross-references back to the Foreign Country Money Judgments Recognition Act, which authorizes, recognition of judgments that grant or deny relief. And in my view, I see no reason to limit it to that. The example I gave was a situation where someone has filed a money judgment action in the United States, or my example was in Washington County, after losing an identical action in Canada by getting a no result on something that might have occurred in the waters between the United States and Canada, or in the international park off of Lubec in Washington County on Campobello Island. And so it seemed to me where the Recognition Act includes both grant or deny. I thought this should also include grant or deny because it would therefore be useful to either perhaps support precluding an action in the United States where the action had already been lost in Canada, or being offered as a res judicata or laches or other defense. That's why I suggested it with regard to, again, only paragraph or only, sub 2 of 8903, because I think it is already in sub 1 of 8903 by the cross-reference.
Okay. Thank you. I appreciate the chair's indulgence letting me ask Justice Alexander to explain that further. I think with that explanation, I would just defer to Laura what the court's preference is on this. I would probably consider that a sort of a main specific change if you wish to make it. It's sort of a policy decision for you all, I think.
Given that it's a policy decision, if you want the judicial branch to weigh in, I would have to take that back to the judicial branch, because I merely answered the questions that were posed to me, and I don't think I should weigh in on that. I understand, and I think it's clear and helpful, but I am not the decider, clearly.
Thank you.
Maybe
Caitlin,
you could ask Amy Quinlan if you wish. She could.
Caitlin, I wanted to ask you a question. If I totally understand, Justice Alexander, why it's important to think through this issue and the importance of being able to use a judgment to absolve yourself from liability or to defend against a claim. But could a US citizen who is facing the kind of situation that Justice Alexander described, could they resort in a dispute involving a Canadian, could they resort to the protection afforded under the Foreign Country Money Judgment Recognition Act in order to use a judgment in that same way?
Yes, yes. Using the Recognition Act, Chair Carney, is certainly an option, and that's what we touched on earlier. This registration piece is an alternative. is meant to be sort of a streamlined alternative for perhaps less complex cases where there's not litigation going on other topics as well. But yes, that would remain an option.
Yeah, and certainly that defensive use, so to speak, would be more complex. Justice Alexander, did you, and then we'll call on you, Representative Babbage, but would love to hear your thoughts.
Yeah, what that does require filing an action though. And I'm thinking there may be situations where you want to deter an action or all without the going through the burden of filing an action, particularly if you're defending something, you may not want to be initiating an action. So that's why I suggested it.
Yeah, that makes a lot of sense to me as well. Thank you. Representative Babish, go ahead.
Thanks. This is just like a 30,000 foot question. I'm when I look at uniform law, and we have some states adopting and others not, and so forth, and we tweak it, but I guess I am wary of us putting ourselves in a position where litigants could go state shopping, and I just wondered, given Justice Alexander's wording here and what's before us, I was concerned about that, but it seems to me maybe that that the wording before us actually would solve that more so than create the problems. Is that true?
There.
Yeah, that's my impression. I think.
Sure, I'm trying to get the sound on
Justice Alexander.
I'll be in a minute.
Okay. Sorry. I viewed it as a way to facilitate using the judgment, the Canadian judgment in Maine in both the grant or deny situation. I frankly didn't consider the state shopping thing. I think that would be difficult in a lot of the cross-border dealings between Maine and, between, let's call it Washington and Aroostook County businesses and people, because basically that's your shopping area for an action that goes those ways, unless there's some type of federal action. I hadn't really considered that issue, Representative Babbage.
Okay, thank you. I was concerned about large moneyed interests that might have those options.
Mm-hmm.
Representative Reckitt. Oh, I think we lost Representative Reckitt. Let's give her just a minute. And Representative Babbage, you're all set with your question, right?
I will take care of that.
Let me see if I can. Yeah, I'm not sure what happened with Representative Reckitt. I hope that she will return in a moment. There she is. Representative Reckitt, do you want to go ahead with your question?
Can anybody hear me?
We can hear you.
I've entirely lost audio. I can't hear any of you at all. And I've gone out and come back in to try to do something about it, but I can't seem to get sound. I have no idea what's going on.
You can hear us now.
So,
can you hear us now?
Unless my sign language is not good enough that I could continue that way, but I just have no clue what to do. So. Maybe I should go out for a time period and then, as opposed to briefly, and see if that works. But
it does look like other people in the state system have been experiencing audio issues. So I don't know if this is just one more instance.
Lois, we could hear you a moment ago. I think inadvertently your mic was not off. So we are hearing you now.
I'm going to ask her to sign off and sign back on. But I can't chat with her because she signed off. Okay, let's proceed. And I'm sure that she will rejoin us shortly, and then we'll take her question. At this point, I think we'll move from hearing from Laura Perlman and Justice Alexander and Caitlin Wolf. We'll send you back to the attendee space and ask you to stay there because we may have a question or two for you, and we will engage in our committee discussion. Thank you. And okay. Representative Moriarty.
Thank you, Madam Chair. It appears to me that we're very close to reaching universal agreement on terminology and so forth. And I wonder if it makes sense to table this, send it back to Peggy and the three presenters who've addressed us this afternoon, and give them a little bit of time to just reconcile some of the nuances that have been articulated.
So taking into account, so your thought is that Peggy would present us with an updated amendment that incorporates all of the changes that we've heard about today. And would that also include adding to the Canadian Judgment Act in section 8903 sub 2, the word or denies in the first sentence and the word or denial in the third line of that?
Yes, yes, it would. And for some reason, I don't have Justice Alexander's letter, so I'm not sure what other points he may have made that haven't been actually raised orally this afternoon, but perhaps a single conference call could take care of that.
Mm-hmm. Okay, and so what we would do is have Peggy prepare the amendment, and then we would schedule this for another work session that would be much briefer because we have done the deep dive. And perhaps if there was something else from Justice Alexander's letter that you wanted to bring up, we could, of course, address that or any other suggestions at the final work session. But we would think of that final work session as a movement toward voting on this legislation. How does that feel to committee members? Is everybody okay with that? Okay, I couldn't. Go ahead, Representative Sheehan.
I was just going to say that I'm totally fine with that. If everyone feels that they need to see the language.
Okay, yeah, and if we voted on it without the language before us, we would have a language review. So I think it makes sense to do it all in one fell swoop. All right, Representative Moriarty, do you have a motion for us?
If there's no one else in the queue to speak, then I'll make a motion to table at this time.
Thank you. And is there a second? Seconded by Representative Sheehan. And Representative Hagan, welcome. I don't know that we've seen you today. It's good to see you. Okay, and so we have a motion to table that's been seconded. And Supi, we're ready for the vote whenever you are.
Thank you, Madam Chair. Representative Galgay-Reckitt. Representative Newell. Representative Evangelos. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kine. Senator Sanborn.
Yes, sorry. I couldn't find my unmute button. I vote yes.
Thank you, Senator Kine. Senator Kine votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Sheehan.
Yes.
I don't see you. Oh, there you are. I'm so sorry. Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos. Representative Evangelos is absent. Representative Harnett. Representative Harnett is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 members are absent.
Thank you very much, Supi. And with that, the motion to table on LD 903 carries, and we will reschedule that once we've got the amendment completely prepared. And I think we are done with our committee work today. And so I would entertain a motion to adjourn. Moved by Senator Kine. Is there a second? By Representative Thorne. And so we will be adjourned until we reconvene tomorrow morning at 9 o'clock. Thank you, everyone.
Okay.
Thank you.
Good night.
And thank you, Caitlin. Thank you, Laura. Thank you, Justice Alexander.
I won't ask for a roll call.